Okay, I have YouTube streaming this live. This is going to be the case of State of Georgia versus Tammy Renee Atkins. She's charged in warrant number 2021 WA 21493 with committing the offense of criminal trespass. Mr. Simeon, you have the floor.
Thank you. The state would like to call Officer Robert Golden, to the stand. Good morning, Officer Golden.
Good morning.
Can you please raise your right hand? In this matter, do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you. Officer Golden, can you please state and spell your name for the court?
Yes. First name's going to be Robert, Robert. Last name's going to be Golden, Golden.
And can you please state, sir, with whom you are employed at this time?
Yes. Clayton County Police Department.
And is this the same is Clayton County Police Department the same employer you had at the date of this incident?
Correct.
How long have you been with Clayton County Police Department?
About 18 months.
18 months. Over the course of your back up. Are you post-certified, sir?
Yes.
And over the course of your 18 months, have you responded to incidents similar to these in the past?
Yes, I have.
Approximately, if you could round off about approximately how many, sir?
I'd probably say probably five.
5, roughly?
Yeah.
Okay. So on the incident date, December 27, 2021, you responded to the area of Castile Drive, which led you to 2589 Sparta Drive, and that's located in, Morro. Is that in Clayton County, sir?
Yes, it is.
Now, upon encountering the subject, can you please tell us what information you uncovered, sir?
Yes. So at first I met with a Mr. Ernest subject. He was in his underwear, like rambling about a lot of random things. He said he needed police to go to his house. When we asked him where his house was, he could not provide numerics. He just said it's a house with a white garage. If you let me get in the car, I'll basically point you in the direction of my house. So once we pat him down, put him in the car, that's when we ended up at the 2589 Sparta Drive location.
Okay. And you transported him to his house as requested, correct? Or his house as requested?
Yes, correct.
When you got there to that house, what did you see?
When we pulled up to the house he advised was his residence, from first appearance, you could tell the house had been abandoned for roughly a long time. Trash place, overgrown grass, no electricity. And when I asked him, hey, is there anybody else inside? He said his girlfriend, Tammy. And at that point, that's when we went up to the residence.
And did you find this person named Tammy inside, correct?
Yes, I found a Miss Tammy Atkins. She was in the back bedroom, laying on, she was on the floor.
Okay. And do you see, based upon your view, I don't know if you're on your phone or laptop, tablet, do you see someone that resembles the defendant, Tammy Atkins, on this call?
Mine's only showing you and me right now. Let me swipe real quick and see. Hold on. Okay, yes.
Can you identify her with an article of clothing, please?
Yeah, she's had a green jump shirt, white mask below her nose, and brown hair.
All right. Thank you, Your Honor. Let the record reflect that the officer has identified the defendant as Tammy Atkins.
Okay, proceed.
Thank you. So Did you encounter or speak with Miss Atkins at all at the incident date?
Yes, I did.
And what did she commute to you?
I asked her simple questions at first, say like, do you live here? What are you doing here? Who do you live here with? And she advised that she's been staying there for a few days and she stays with her boyfriend, Ernest, the male I picked up on the side of the road.
Okay. And you said they've been staying there for a few days. Did they advise that they own that property?
No, they advised that the owner of the property was Miss Hilton, the next door neighbor, and that Miss Hilton advised both of them that they were both allowed to stay in the house.
Okay. So did you speak with Miss Hilton?
Yes.
And what was communicated to you?
When I went next door to Miss Hilton, she advised that no one's supposed to be in the house and that she's had problems in the past with people like breaking into the house, ODing in the house. She said she's had multiple calls to service to that location due to, I presume, homeless people just declaring that their residents.
So she conveyed to you that despite what the defendant told you, that they had access to this property, they were not supposed to be on this premises.
Correct. She advised no one was supposed to be inside their house next door.
And this was an incident, or this was an issue that they've had problems with before.
Yes, this had been an ongoing issue.
So did Ms. Hilton, was she able to see, did you show her the defendant in this matter? Was she able to see who was actually in her house at this time?
I showed her Mr. Ernest, because obviously he was the first one we came in contact with. Right. And she said, I don't know who that is. I've never seen him before. I don't know why he's in our house next door.
Okay. Thank you, Officer Golden. Your Honor, the state has no further questions.
Mr. Little?
Thank you, Your Honor. Officer Golden, when you saw this residence, were there any no trespassing signs posted around the residence?
No.
Okay. And you said when you spoke to Miss Hilton, she told you that she had never seen Ernest before?
No, she had no idea who he was.
So she had never spoken to him before?
No.
And did she give any indication of whether she'd spoken to Tammy Atkins before?
No.
Okay. Did Miss Hilton point out any property damage at the property?
She pointed out property damage that had taken place in the past. Someone had like broken a window. There's like holes in the walls, but she said it's been an ongoing issue. Nothing that had happened the night this incident took place.
Okay. Thank you. Those are the questions I have at this time.
Any redirect?
No, Your
Honor. May Officer Golden be excused?
Yes, Your Honor.
Okay. Is there anything else the state plans to put? Any other evidence that state plans to put on?
No, Your Honor.
Is there any evidence from the defense?
No evidence, Your Honor, just argument.
Okay. The state, are you going to have any argument, or are you just going to wait and respond?
The state would wish to provide an argument at this time, Your Honor.
Okay.
So, Your Honor, the defendant, Ms. Tammy Atkins, is charged with criminal trespass at this time. It is not a criminal trespass that pertains to any damages under $500 or less. This is regards to being on the premises without having proper authorized access. It is of the impression by the state, and we firmly believe that Officer Golden has provided testimony to the extent that Ms. Tammy Atkins at this time had no access or no permission to be at 2598 Sparta Drive in Morro, Georgia, here in Clayton County. Ms. Atkins was under the impression that she had access for whatever reason. However, when the officer spoke to the rightful owner of the property, she advised that no one should be on that property at all. She's had issues with squatters in the past to whereby she's contacted authorities, and she's mentioned that to Officer Golden here, as he mentioned that he provided in his testimony. And the state humbly requests that the court find that there, based upon the testimony provided today by Officer Gordon, that there is sufficient evidence to support a charge of criminal trespass against the defendant, Ms. Tammy Atkins.
Mr. Little?
Your Honor, the state concedes that this is not a damage case. Ms. Hilton didn't claim that there was any damage caused by Ms. Atkins at this residence. For criminal trespass under OCGA 16-7-21, a person commits the offense of criminal trespass when he or she knowingly and without authority enters onto the land or premises of another person or into any part of any vehicle, railroad car, aircraft, or watercraft of another person after receiving prior to such entry notice from the owner, rightful occupant, or under proper identification and authorized representative of the owner or rightful occupant that such entry is forbidden. Officer Golden testified that there were no trespassing signs on the property, and that Ms. Hilton confirmed that she had never spoken to Tammy Atkins before, had never seen Tammy Atkins before, and therefore could not have given her a criminal trespass warning. We have no evidence that anybody has ever told Tammy Atkins that she wasn't allowed to be on that property. And so because she had no notice that she was not allowed to enter onto that property, we would argue that the state has failed to meet their burden of probable cause for a criminal trespass in this case, Your Honor.
Mr. Simeon?
Yes, Your Honor. The state is of the opinion that the unlawful purpose for which the defendants were on this property, Your Honor, is that the property does not belong to them. They had no permission, as defense pointed out. They didn't have that permission to be on that property, and that in itself is unlawful. Squatting is unlawful, and the defendants in this case operated under whatever assumption that they derived or that they mentioned to the officer that they had permission, whereby the rightful owner, Ms. Hilton, spoke to Officer Golden. She saw, I guess, the defendant's accomplice or acquaintance, rather, and stated that she never seen that man in his life, never seen that man in all her life. That neither he nor the person that he was with or whomever decides to take up residence in that property, albeit abandoned, has no permission to be there. This is a prior issue that she's had on repeated occasions, and I believe this is also evidenced by the defense's mention of damaged property. Although this is not a damaged property case, the defendants in this matter had no permission to be on this property, and that in itself is unlawful, notice or with or without notice. The state firmly requests that the evidence as provided by Officer Golden by the state supports probable cause, the charge of criminal trespass in this instance.
Do you know if the male acquaintance or acquainted, if he was arrested also?
Oh, Your Honor.
Yeah, I arrested Ernest and Tammy both on the same night. They both went to jail.
Okay. Officer Golden, let me ask you this, since you're still on the line.
Of course.
Why wasn't a criminal trespass warning given to both of them?
My supervisor advised me to place them both under arrest and take them for CT for being inside the house for multiple days and having no rights to that house, just basically taking up residence in an abandoned home. So under the direction of my supervision, I placed both subjects under arrest for criminal trespass.
And Your Honor, just sorry to interrupt, but I did find, I forgot to mention that Mr. Ernest was, I believe his name is Ernest Harris, and he was arrested on this incident. He did have his hearing before Judge Hayward, I want to say on January 25th of 2022, and he entered a plea therein.
Hmm. Okay, I'm gonna find that there is not sufficient probable cause for this case to get bound over to state court. Mr. Little, I need you to prepare an order for that.
No problem, Your Honor.
Okay,
Actually, Judge, I already
Yes.
have.
oh, you do?
Yes, I got it.
Okay, all right, send it over to me.
Okay, I will. Did
All
you
right.
hear that, Mr. Little?
Yes, the court's gonna prepare the order.
Yes, sir.
Fantastic.
I'm
Okay,
gonna send it to you right now.
The next case is Shawayne Brinker.
Thank you, Your Honor. At this time, the state would like to call Officer Danielle Brown to the stand.
I would request that we wait until Mr. Branker is present at the hearing, though.
My apologies.
There she go. See?
After the Brinker case, the next case that's called is going to be Hammett with Officer Lane. And after that, it'll be Mallet with Officer Wynn. Okay, okay, there we go. Thank you. This is going to be the case of State of Georgia versus Shawayne Zawandi Brinker. It's charged in warrant number 2021 WA 21672 with committing the offense of criminal trespass. You may proceed, Mr. Simeon.
Thank you, Your Honor. At this time, Your Honor, the state would like to call Officer Danielle Brown to the stand. Good morning, Officer Brown.
Good morning.
Could you please raise your right hand for the court? Do you swear in this matter to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Could you please state and spell your name for the court?
My name is Danielle Brown, Danielle. Last name Brown, Brown.
Thank you, Officer Brown. Can you please, with whom are you employed right now?
Clayton County,
I'm sorry, you're breaking up.
Clayton County Police Department
Thank you. How long have you been employed with Clayton County Police Department?
for 2 years.
2 years, and are you post-certified?
Yes, sir.
Now, in your 2 years of employment with Clayton County PD, have you responded to incidents similar to this in the past?
Yes, sir.
Approximately about how many? Just roughly.
Yeah, approximately three a day, 4 or 5 a week.
Okay. Thank you. Now, could you, on December 31st of 2020, it appears you responded to 1387 Quail Hunt Drive in Riverdale, correct?
That is correct.
And that's located here in Clayton County?
Yes, sir.
Now, what was the reason for that, you being dispatched at an incident location?
I was responding to a domestic call with a demented person.
Okay. And did you make contact with the victim upon your arriving?
Yes, sir.
And what is the victim's relation to the defendant in this case?
She was his mother.
His mother?
Yes.
Officer Lane, can you please put your microphone on mute, please? Thank you, Officer Lane. I apologize, Officer Brown. I apologize, Your Honor. And can you please share with the court what you uncovered that day?
Upon arrival at the residence, the victim, Miss Patricia Branker, was outside sitting in her car in the driveway. She advised me that she was afraid of Mr. Branker, her son, Mr. Sherwayne, due to him not having taken his meds and being off meds, being a schizophrenic and also diagnosed with bipolar disorder. He has violent tendencies. She was deathly afraid of him at that time, which is why she remained outside until the police arrived. Upon speaking with her, she advised that Mr. Sherwayne had punched a hole in her door last night while she was in her bedroom with her door closed. She advised that he came to her door, banging on her door, asking her to give him his bank card and his license. She told him she does not have it, to leave her alone and to go so she can go to bed. She advised he continued to bang. She advised him to leave her door. And as a result, he punched a hole into her bedroom door, causing a substantial hole into the door. Causing a substantial hole in the door. So I advised her she needs to let me see it due to the fact that it was damage that can't be visible. She took me into the house where I made contact with Mr. Sherwayne.
And thank you, officer. And upon entering the residence and viewing this door, you noticed that damage, correct?
Yes, sir. It was a substantial door to the upper left side of that door.
Okay. Now, did you do anything else with this door upon your investigations?
Yes, sir. I entered Miss Patricia's room with her permission. She advised me that he hit the door from the outside in. I looked around the bedroom to see if I could see any debris from the damage. I found two wooden plates that belonged to the door. The reason why I know it belonged to the door, I put both wooden plates up to the door, and they matched the damages that were sustained at the door.
Thank you, Officer Brown. Your Honor, the state has no further questions.
Mr. Little?
Did you have a chance to speak with Mr. Branker about the damage to the door?
I did.
And what did Mr. Branker tell you?
Mr. Branker advised that somebody else did it because Miss Patricia allows other people inside of the residence also ramble on stating that he was a trainer. He trained all police officers, that Miss Branker steals from him or keeps his items in her room. He also advised that he was a master trainer. He kept reiterating the fact that he was a master trainer and that it's multiple people in the household. Upon due to the fact that he had not been taking his medication and he had been diagnosed with schizophrenia and bipolar disorder, he was showing signs of paranoia.
Did Mrs. Branker, did she indicate that there were any other people in the home?
Ms. Branker advised that they are the only two that reside in the residence.
Okay. And did she tell you this damage happened overnight?
She told me that it happened early that morning at possibly 2 a.m., 2 to 3 a.m.
Okay. And then when is it that you responded?
I responded later, approximately, it was light, so it was about 9 o'clock.
Okay. Those are the questions I have at this time.
Okay, any redirect?
No, Your Honor.
Okay. May Officer Brown be excused?
Yes, Your Honor.
Officer Brown, you can be excused. Thank you for attending here. Is there any argument?
Yes, Your Honor.
Go ahead, sir.
The state prays that the court finds that there is sufficient probable cause for a finding for criminal trespass against the defendant in this matter, Mr. Shawayne Branker, based upon the fact and the officer's testimony that the defendant damaged property whereby he punched a hole of a substantial size in the door of his bedroom door of his mother, causing damages in amount of less $500 or less. The officer thereby corroborated this finding by picking up the pieces of this door and placing them in the door to see if they matched that door, similar to a puzzle, just finding those pieces of the door and placing them in there to make sure that this was a door that was damaged. And she corroborated and confirmed that the door was damaged. According to the comments or as provided to her by the victim, the defendant's mother, Ms. Patricia Branker, the state respectfully asks that the court find that there is sufficient showing of probable cause for a charge of criminal trespass against the defendant in this matter. Thank you, Your Honor.
Thank you, sir. Mr. Little?
Your Honor, we'll rest on the evidence, Your Honor.
Okay. I think there's sufficient evidence to bound this case over to the state court of Clayton County. So that will be my order. Next case I have is Hammett. Mr. Branker is free to go back. Can we call up, bring up Alex Hammett? Okay. Looks like we have Miss Hammett present. This is going to be position 3, State of Georgia versus Alex Hammett. She's charged in warrant number 2021 WA 21660 with committing the offense of battery. Mr. Simeon, you may proceed, sir.
Thank you, Your Honor. The state would like to call Officer Lane to the stand. Good morning, Officer Lane.
Good morning, sir.
Can you please raise your right hand, sir? Now, in the matter before you today, do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, I do.
Thank you. Now, Officer Lane, could you please state and spell your name for the court?
My first name is Jason. First name spelling Jason. Last name is Lane. Last name spelling Lane.
Thank you, Officer Lane. Now, with whom are you currently employed?
City of Lovejoy Police Department.
And how long have you been employed with Lovejoy Police Department?
Approximately 1 year and 3 months.
1 year and 3 months. Now, are you post-certified, sir?
Yes, I am. I've been a certified police officer for over 27 years.
Okay. Now, were you employed at any other departments other than Lovejoy?
Yes, sir. I work for City of Lithonia Police Department, Fulton County Sheriff's Department, and DeKalb County.
Thank you, sir. Now, over the course of your 20 years of experience, sir, have you investigated matters of this kind before?
Yes, sir, I have.
All right. Now, on this date in question, sir, you were dispatched with respect to a disturbance at 816 Cambridge Parkway in Lovejoy, correct?
Yes, sir. That's correct.
Now, is that here in Clayton County, sir?
It is in Clayton County, inside the city limits of Lovejoy.
Thank you, sir. Now, upon you being dispatched to 816 Cambridge Parkway, you weren't able to locate the disturbance, is that correct?
That is correct. Myself and another unit was dispatched to that location. When we got there, we were not able to locate a disturbance at that location. So we went to the residence and knocked on the door. I spoke with the homeowner at that residence, and she told me that she observed a black male and female fighting in front of her residence, and said that after a few minutes they drove off. She described the car as being blue, but actually it was gray. But anyway, she gave a detailed description of them fighting and being loud, and that's why she called the police. When we got there, they was gone. After we cleared that location, we drove around the mobile home. It's a mobile home community. After we drove around the community for several minutes to try to locate, see if they moved to another location inside the community, we was not able to locate. So we went back in service. I pulled up at the 76 gas station located at 11440 Hastings Bridge Road to start on a report in reference to another unrelated case I had to do to knock out my report. During that time, a motorist pulled up and approached me and said that there was a vehicle in the ditch in front of the Gates subdivision, which is a newly constructed subdivision in the city of Lovejoy that's located on Hastings Bridge Road, right at Bridgewater Pass. It's a gated community. Once she advised me there was a vehicle in the ditch. I went to that location to investigate. When I got there, I did observe a vehicle in the ditch. It turned out to be a Chrysler 200 gray in color. I also noticed both of the offenders, Miss Hammett and Mr. Pickens, they was outside the vehicle arguing at each other, yelling at each other. I think Miss Hammett was crying at the time. So I got another unit there. We separated both parties. I spoke to Miss Hammett first. She said during actually after speaking with her, she told me what happened. Her and Mr. Hammett got into an argument. The argument led to him putting his hands around her, choking her. And that's when she lost control of the vehicle. And that's how the vehicle ended up in the ditch. So once she told me that, I realized then that this incident was more than likely related to the disturbance that was over off Cambridge Parkway. While I was speaking with her, I noticed she did have bruises and scratches around her neck, which indicated to me that somebody did put their hands around her neck and was choking her. So we started emergency service unit to come out and check them out, but she refused. She didn't want medical attention. Once I secured her and placed her in my vehicle, we then spoke to Mr. Hammett, and he stated that they got into a physical altercation because he wanted to terminate the relationship. And during that time, he said that she assaulted him at the initial location where we were dispatched to at 816 Cambridge Parkway. That's where the incident actually started and took place. He did have injuries on his chest area and arms areas, which I took pictures of and attached it to the report. And he pretty much stated that he wanted to terminate the relationship with her. She got upset and got violent, and he stated that she struck him she assaulted him first. After interviewing both of them, I found I had probable cause to arrest both of them, so they were both taken into custody and transported to the Clayton County Jail.
Yes, sir. So let me just take a step back. So did this incident occur at daytime, nighttime?
It was at night, sir. It was around 11:07 p.m.
Okay.
It happened at night.
So you made mention that, the resident at 816 Cambridge Parkway said it was a blue automobile sedan, but turned out to be gray.
It turned out to be gray, yes, sir.
Was it also a sedan?
It was also a sedan, yes, sir. Chrysler 200 four-door sedan.
Now, the incident, when you pulled up Ms. Hammett and Mr. Pickens' information, did it show that they had a residence at 816 Cambridge Parkway?
No, sir.
It did not.
It did not show. No, sir. When I ran both of them on GCIC, Ms. Pickens had an address on Kayla Drive, which is the subdivision next to the Gate subdivision where the vehicle was off into the ditch. Actually, she stayed in the subdivision next to that subdivision.
Gotcha.
Mr. Hammett had an address out of McDonough, Georgia. So I'm assuming he was coming to visit.
Got you. At any point, was the address or the call that was made at 816 Cambridge Parkway, was that correlated at any respect to the residence of Ms. Hammett or Mr. Pickens? For instance, even though their information on their driver's license didn't say 816 Cambridge, did in fact, did they have a domicile or some type of residence at 816 at any point?
No, sir.
Okay, and how far away is 816 Cambridge from the Gate, that Bridgewater Pass subdivision?
A little bit less than a half a mile.
And is that
approximately a little bit less than a half a mile?
And is that still in Lovejoy?
That's still in the city of Lovejoy, yes, sir.
So you would still have jurisdiction?
Actually, we still have jurisdiction, yes, sir. Actually, the address that came back to Miss Pickens, she actually stayed off Hastings Bridge Road. Her neighborhood is right next to the neighborhood where a vehicle where I located her vehicle in the ditch.
Gotcha. Okay,
Next to the newly built subdivision, the Gate subdivision. Her subdivision is right next to that. So they
Gotcha.
actually, she was right there in front of her subdivision.
got you. So even though, and we could, even though the defendant, Ms. Hammett, it appears that this might have been a separate call. However, this led you to a separate incident whereby you discovered Mr. Pickens and Ms. Hammett had been in some physical altercation or something physical, some type of physical altercation had gone down with regards to a disagreement.
Yes, sir.
And you noticed that I think Mr. Pickens, he showed you, he recorded some of this, I guess some of the physical altercation, correct?
Yes, sir. He said he recorded it on his phone. I reviewed the footage that he had on the phone, and I was not able to see a physical altercation take place on the phone, but you can hear the altercation going on where it appears that she was striking him. And he was telling, I guess he was telling her that she needed to get off of him, but you can hear that. You can hear the altercation, but you couldn't actually see it on his phone. The
Gotcha.
footage was not good.
And you did see, I see you saw an abrasion under his eye, correct?
Yes, sir. He had abrasion under his eye. He also had bruising and scratches on his chest area and on his forearms.
Now, did this appear to be fresh?
It was fresh. Yes, sir.
Okay. And also that incident location where you found the car in the ditch, you did mention that's in Lovejoy. Is that still within the realm in the jurisdiction of Clayton County?
Yes, it is.
Okay. Thank you, Officer Lane. Your Honor, no further questions.
Mr. Suh.
Thank you, Your Honor. Hello, Officer Lane.
Good morning, sir.
Good morning. Just a few questions. Let's start with, were you wearing a body-worn camera during the investigation?
Yes, sir, I was.
Yes. And was it recording?
Yes.
Excellent. So that should be available for review. I'm asking,
Yes,
so that
sir.
should be available for review?
Yes, sir. Yes,
Excellent,
sir. It's
excellent.
available for review. Yes, sir.
And just to confirm, you were able to record the entire investigation, all of the questions with all the witnesses?
Yes, sir.
Excellent. All right. Now, Mr. Pickens alleged that he himself was also attacked. Mr. Pickens being the alleged victim of Ms. Hammett's case.
Okay.
In your report, you wrote down that he indicated he was punched by her. Can you confirm that that's what you wrote? And that's what he said?
Yes, sir. That's what I put in the report. Yes, sir.
Now, the injuries you also indicated were to his eye and his chest, and correct?
Yes, sir.
Now, the report, as well as the pictures, indicate that there were scratches. Would you say that those are the type of injuries that can occur from punches?
Yes, sir.
From punches?
From punches.
Okay. Now let's double check. Where did Mr. Pickens indicate that those attacks allegedly occurred from? Or like, where were they?
He said that attack initiated at 816 Cambridge Parkway in front of the resident that called it in that wanted to remain anonymous. That's where the incident started.
So he's not saying it occurred in the car itself.
That is correct. He's saying it did not occur in the car itself.
Okay. And I just want to confirm one more thing. You saw a cell phone footage of the incident that Mr. Pickens provided to you. And just to confirm, it was pretty much audio only. You couldn't visually see the actual indication.
That is correct.
The altercation. Okay. Yes.
Yes, sir.
Thank you, officer. No further questions at this time, Your Honor.
Any redirect?
No, Your Honor.
Okay. May Officer Lane be excused?
Yes, Your Honor. Thank you, Officer Lane.
No problem. Thank you, sir.
Okay, is there any witnesses from the defense?
No witnesses from the defense, Your Honor.
Okay, any argument?
Yes, Your Honor. The state requests that the court find that there is sufficient justification for a charge of probable cause, battery against defendant's matter, Miss Alexis Hammett. Excuse me, I apologize, ma'am. Although there was a mix-up in incidents regarding the dispatch call to Officer Lane, he uncovered that there was a physical altercation between the defendant and Mr. Pickens in this matter, whereby one, the defendant punched him and scratched him in the chest and facial area, whereby there was an abrasion under his eye, his left eye, and redness on his chest area. There's also video footage, not only from the body-worn camera, but also video footage from Mr. Pickens in this matter, whereby you could hear the defendant striking Mr. Pickens, which led to the observed abrasion under his eye and markings on his chest. And the state finds that that is sufficient, a sufficient showing of substantial harm and substantial damage to one's serious bodily injury, to one's body. Your Honor, the state again humbly finds that that you find that there is sufficient justification for a charge of battery against the defendant in this matter, Ms. Hammett. Thank you.
Thank you, Mr. Suh.
Your Honor, one of the ways to combat battery charges, to whether to see if it's an arrestable offense, is to see if it was consent involved. In this case, I submit that this alleged attack that my client did to Mr. Pickens. The officer and Mr. Pickens indicated this occurred at some time before this car accident, at some time before the incident that gave rise to the car accident itself. I cannot confirm or deny where those scratches came from. I do have questions on whether punches can actually cause scratches as indicated by the images I saw, but I'll leave that to the court's discretion. But Your Honor, it seems that they got in the car together. They were traveling together. At no point did, the only time that anything came up was after he was being charged, after he viciously choked our client by the neck. I would submit that, Your Honor, he forgave her and he continued to have contact with her after this alleged initial incident before the car accident. And thus I submit that there is no probable cause, not insufficient probable cause to charge her with battery due to these reasons, Your Honor.
Okay. Anything else, Mr. Simeon?
Yes, Your Honor. The state argues in opposition that this was not consensual and that these events, if they occurred as provided by defense, was all part of one occurrence in this matter. If they occurred, however, the state has shown that there was, based upon the testimony of Officer Lane in this matter, that there was substantial bodily harm or serious bodily injury to the defendant in this matter, whereby there again, small abrasion under his left eye, as well as scratches and redness on his chest area, Your Honor, which would, after being struck by the defendant, which is sufficient to show a sufficient showing for a charge of battery.
Okay, I'm going to find that there is sufficient evidence for this case to get bound over to the state court of Clayton County for these matters to be resolved. I need to take probably a 5-minute break at this moment, but for scheduling purposes, I have Mallet Marcus Michael Sanders Shobi, Stephen, Swingen, Walker, and Warner as to matters that we need to resolve. So it shouldn't take me 5 minutes, but I do need to stop for a moment.
Yes, Your Honor.
Thank you, Your Honor.
Okay. Okay, I'm back. Thank you for your patience. See, I have Mr. Mallet as being next, and I believe that's Mr. Suh's client. So can we bring up D'Angelo Mallet? Let's see, we have Officer Wynn. Okay, for the record, it's going to be State of Georgia versus D'Angelo Michael Mallet. He's charged in warrant number 2021 WA 21581 with committing the offense of giving a false name, address, or date of birth. Mr. Simeon, you may proceed.
Thank you, Your Honor. Good morning, Officer. Good morning, Officer Nguyen.
Good morning, sir.
You mind raising your right hand for me?
Yes, sir.
Now, in the matter today, do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Officer Nguyen, can you please state and spell your name for the court?
My first name is spelled D-U-Y. My last name is spelled N-G-U-Y-E-N.
Can you say your name for the court?
Dewey Nguyen.
Dewey Nguyen. Thank you, Officer Nguyen. Now, can you please state to the court with who are you employed with right now?
I'm employed with the Clayton County Police Department.
And how long have you been employed with the Clayton County Police Department?
For a little over a year now, sir.
Now, in your experience with Clayton County PD for a little over a year, have you responded to incidents like this in the past?
No, sir. This was my first one.
Your first one?
Yes, sir.
Are you post-certified?
Yes, sir.
Now, you responded, it says you responded on December 29th of 2021, responded with reference to a robbery location being at the intersection or near Battle Creek Road and Terra Boulevard in Jonesboro, correct?
Yes, sir. That's correct.
Now, is this located in Clayton County?
Yes, sir.
Okay, so you made contact with the defendant in this matter, Mr. D'Angelo Mallet, correct?
Yes, sir.
Now, when you asked him if he had an ID, did he have one on him?
No, sir.
When you asked him his name, what did he tell you?
He told me that his name was Alex Mallet, and I
Alex.
looked. Yes, sir. Yep.
Okay. And when you pulled this information that he gave you as Alex Mallet, did it appear in GCIC?
Yes, sir. The description did not fit his description. It came back to a suspect who was 6'3", 290 pounds. He had a lot of weight in his face, and you can visibly see it. And it did not fit the description that, it did not fit D'Angelo Mallet description.
Got you. So you weren't able to, I guess, positively identify him at this time, correct?
Yes, sir. That's correct.
So later, what did you use to identify him later?
I use a rapid ID.
Okay, what is that, sir?
It's like a device where you can fingerprint somebody and it'll pull up information using their fingerprint, where they're from.
Got you. And so you use the rapid ID and obtain the fingerprints of the defendant in this matter, right?
Yes, sir.
And what did that information reveal to you?
He came back to, his name was D'Angelo Mallet. He was 6'3", 175 pounds.
Got you. Did this fingerprint come back with a picture of any sort?
I believe so. Well, I don't remember, sir.
Okay, but you can confirm that upon using rapid ID to get his fingerprint, it came back the name for the defendant being D'Angelo Mallet.
Yes, sir. Yep.
And did he later admit to using another name?
Yes, sir. He did.
Whose name did he admit to using?
He admitted to using his brother's name because he knew that he had a warrant out of Fayetteville.
Got you. And his brother's name was indeed Alex Mallet, correct?
Yes, sir. That's correct.
And the defendant here is D'Angelo Mallet.
Yes, sir.
Thank you, Officer. Thank you, Officer Nguyen. Your Honor, no further questions.
Yes, sir.
Mr. Suh.
I think I was muted. Thank you, Your Honor. Hello, Mr. Nguyen.
Good morning, sir.
Good morning. Let's start with a question. Were you wearing a body-worn camera during this investigation?
Yes, sir.
And was it on and recording during the
Yes.
entire investigation?
Yes, sir.
All right. Now, I also want to confirm you were provided a description of this alleged in reference to the robbery initially. Is that correct?
Yes, sir.
And where did you get that description from? Who provided it again?
It was the victim, sir.
Okay, it's the victim provided. Okay. And could you repeat what was that description?
The description was not very descriptive. She just gave us a description of a tall black male wearing dark coloring.
Okay. And that's it? Just tall black male with
Yes, sir.
dark clothes?
Yes, sir.
Now, I want to ask, in your police report, it indicates during the investigation, I detained D'Angelo Mallet. Could you be more specific? How did the actual detention occur? Not the arrest, just when you first laid eyes on him and the point of, I guess, approaching him. Could you describe that incident?
I didn't particularly detain him, sir. My sergeant, Sergeant Bashir, detained him. I later switched him over to my patrol vehicle to free up Sergeant Bashir's patrol vehicle.
So just to confirm, when you took over the investigation, is that fair to say? I guess you took over the investigation with Sergeant Bashir?
The only reason why we switched him over to my patrol vehicle was because we was going to take him to the Clayton County jail, but we didn't know what his name was. Well, not take him to Clayton County jail. We was detaining him to get more information because at the time there were more than one suspect.
Okay. Okay, so there's multiple suspects at that time.
Yep. Yes, sir.
Could you give a count about how many suspects there were at that time?
It was about, I say, at least three.
And just to confirm, all three of them were already detained once you arrived?
Yes, sir.
Okay. All right. Thank you, officer. No further question, Your Honor.
Any redirect?
One moment, Your Honor. Yeah, no further questions.
Okay, may Officer Nguyen be released?
Yes, Your Honor. Thank you, Officer Nguyen.
Okay, sir, you're free to go if you so choose. Is there any evidence the defense plans to put up?
No evidence, Your Honor.
Any argument from either side?
Yes, Your Honor. So in this
Okay.
matter, pursuant to an investigation being led by Clayton County police officers, the defendant in this matter, Your Honor, provided the officers a wrongful name. The defendant also provided that, also admitted that he used a false name, the name of his brother, Alex Mallet, whereby the defendant's case name is obviously D'Angelo Mallet. Your Honor, I find that based upon the facts that's provided by Officer Nguyen, whereby the defendant used another person's name in place of his own, that there is sufficient probable cause to support a charge of giving false name against D'Angelo Mallet in this case. Thank you.
Okay, Mr. Sa.
Your Honor, we will submit on the evidence.
Okay, I found that there is sufficient evidence to bound this case over to state court. So that will be the court's decision today in this case. Can we bring up Mr. Michael Marcus?
Your Honor, if the state may, I believe we have Officer Farrah Shelley here on the Glenda Walker case. I know mentioning, going just knocking them down alphabetically, but I believe Officer Shelley has a prior engagement, and I know she was here, I want to say last week, and waited patiently, and they weren't able to proceed on this matter. And I was wondering if we could possibly go forward with that one at this time and in the Zoom.
Yes.
Thank you, Your Honor.
So we're gonna call case State of Georgia versus Glenda Walker. Is that gonna be your case, Mr. Little?
It is, Your Honor.
Okay. All right, looks like we have Ms. Walker present. This is going to be the case position 21, State of Georgia versus Glenda Walker. She's charged in warrant number 2021 WA 21296 with committing the offense of theft by shoplifting. She's charged in warrant number 2021 WA 21297 with committing the offense of disorderly conduct, and she's charged in warrant number 2021 WA 21298 with committing the offense of obstruction of an officer. Mr. Simeon, you may proceed.
Thank you, Honor. One moment, please.
Yes, sir. And just so all parties know, I have no preference in the order that these cases are called. If there is any issues as it relates to a witness or anything like that, please bring it to my attention and we can call the cases out of order. But I have to sit in here and listen to everything. So there's no particular case that I'm excited about or disenchanted about. I got to hear it all.
Thank you, Honor. Good afternoon, good morning, excuse me, Officer Shelley.
Good morning, how are you?
I'm well, and yourself?
I'm good, thank you.
Could you please raise your right hand? Officer Shelley, in this matter, do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Officer Shelley, can you please state and spell your name for the court?
Farrah Shelley, F as in Frank, ARRAH, Shelley, SHELLY.
Thank you, Officer Shelley. Now, with whom are you currently employed?
City of Atlanta Police Department.
And were you employed with the City of Atlanta Police Department on this incident in question?
Yes, I was.
Are you post-certified?
Yes, I am.
How long have you been employed with Atlanta Police Department?
2 months shy of 11 years.
And over the course of your tenure with the Atlanta Police Department, have you encountered or investigated incidents like this in the past?
Yes, I have.
So I'm going to call your attention to the incident date, December 22nd, 2021. Now, this occurred at the airport, correct?
That's correct.
At 6000 North Terminal Parkway, Atlanta, Georgia.
Yes.
Now, is that located here in Clayton County?
Yes, it is.
That portion of the airport, at least.
Yes, because it's Clayton. That's correct.
Thank you. So you responded, from my understanding, you responded in reference to a theft in progress in the airport, correct?
Correct.
Now, what was stolen?
Can I just read my report so I can get all the facts? Is that okay?
Sure, sure, as needed.
As far as what was it, I was flagged down. I wasn't initially on the call. I was flagged down on the fact that Ms. Walker had just taken a a bottle of Coke outside of the store without paying and left. And they still had her in eyesight. So I was flagged down on that.
Okay. And when you encountered Miss Walker, did she admit to taking that bottle of Coke?
She did.
She did. At that time, did you attempt to apprehend Miss Walker?
Initially, and this is where I will go back to the report because
Sure.
it's a mix of things that happen in that. Sorry, I have my other laptop up. She admitted that she had stolen the Coke. Miss Hunter then stated that she did not want. Oh, I'm sorry. Miss Hunter is the clerk at the store.
Mm-hmm.
She advised she did not want to prosecute. She initially just wanted to get the Coke back and she would be done with it.
Mm-hmm.
So I approached Miss Walker at the shoe shine booth near the store where they spotted her. She immediately stated that she took the Coke and that you can have it back. Once I told Miss Walker that we had to head to the MARTA station, fortunately, Miss Walker was residentially challenged. She didn't have any flight or airport business at the time. She stated that she was not going anywhere. I raised dispatch for another unit. With that said, another unit was en route. While en route to my direction, Ms. Walker stated that she needed to go to the restroom first. So we began to walk towards the north corridor, women's restroom. Ms. Walker repeatedly stated to myself that she was going to fight, that myself and her were going to fight if I touch her. I could tell dealing with, I am CIT certified, and I could tell that I was dealing with someone who was, don't have the quite diagnosis, but she was mentally ill.
Now, what is you said CIT certified?
Crime intervention. Yes. Crisis intervention. I'm sorry.
Okay.
And with that said, Ms. Walker repeatedly stated that verbally stated that if I touch her, we were going to fight. While standing by for the other unit, Ms. Walker became combative before we even made it to the restroom. She then turned towards me and began to swing her filled plastic bag and hands at me in a combative manner, striking me. As I stepped to push Ms. Walker back with one hand, she continued to swing and grab me by my duty belt. I wear it's kind of a holster, if you will, that helps lift the weight off my belt. She grabbed me by my duty belt, and at that time, Officer Bertrand arrived on scene. As I struggled with Ms. Walker, we both fell to the ground. Ms. Walker still would not release my harness strap. That's what it was, from my front right side. I then reached with my left hand and extracted my taser. I turned on the taser and placed it near Ms. Walker's face and neck. She then released my harness strap and placed her hand slightly towards the air. Officer Bertrand restrained Ms. Walker by immediately handcuffing her in the front of her chest. Once myself and two other officers lifted Ms. Walker off of the floor, she began to kick backwards and attempt to strike me. We then restrained Ms. Walker on the shoe shine booth structure while we waited to restrain her in a wheelchair because we were not going to make it to the precinct with her in that manner. Ms. Walker managed to grab my 3 middle fingers on the left hand because we handcuffed her immediately just to restrain her in the front. An attempt to bend or break my fingers. As I used my right hand to encourage Ms. Walker to release my hand, she attempted to bite my right arm. I pushed Ms. Walker's face back until we were able to place her in the wheelchair. And then once we were able to officially restrain her, took her to the precinct, I seek medical attention, and she was arrested for those charges.
Okay, so I'm going to backtrack a bit. At any point upon approaching Ms. Walker and engaging Ms. Walker and trying to, I guess, escort her throughout the airport, were you fearful of your life or your safety?
Once Ms. Walker verbally stated that we were going to fight, and that she wasn't, because we initially weren't going to arrest her, we were going to escort her to the MARTA station. That's
Gotcha.
So once she verbally stated that she wasn't going anywhere and that if we tried, she was going to fight, that's when I raised another unit because I knew it was going to be a problem at that point.
You mentioned that you are CIT certified. You said crime intervention or crisis intervention.
I'm sorry.
And
Yes.
could you please explain to us what that entails? I guess basically for the court that would provide you with the information needed for this encounter.
That training teaches us how to deal with individuals in distress, as well as those who are mentally ill. It gives us tactics, helps us to identify someone who would be mentally ill or in some sort of distress.
And based upon, I know you mentioned earlier that although you don't have a formal diagnosis or didn't have a formal diagnosis at a time, based upon your training and experience, could you tell that something just wasn't right with Miss Walker?
That's correct. Yes.
And that, I guess that thought process led you to I guess, or assume or feel that, something could possibly go wrong here when she said that if you touched her, that you and her were going to fight.
Yes.
Okay. And was that, I guess, assumption supported when, as you were escorting her, I guess a physical altercation ensued?
Yes, that was supported on our way to the restroom. She was causing quite a disturbance as far as profanity, yelling, the things of that nature. We really just wanted to assist her in getting back to MARTA after Ms. Hunter advised that they didn't want to prosecute if she just gave it back. But once it became a problem, she didn't want to go to MARTA. And the minute I tried to escort her, that's what occurred.
Okay. Thank you very much, Your Honor. No further questions. Thank you, Officer Shelley.
No problem.
Mr. Little?
Thank you, Your Honor. Officer Shelley, what behaviors was it that Ms. Walker was showing that made you think that she might have a mental health issue?
Well, once approaching Ms. Walker, she was kind of talking to herself. There wasn't anybody around. She did see me coming. So as I approached her, it was kind of in and out sometimes when it comes to being conscious of, I guess, what she was doing. So as she saw me approaching her, she immediately stated that she had took a Coke. She showed it out of her bag, immediately stated she had took a Coke, and that I could have it back. Was
that before you said anything to her, just upon your approach?
That's as I approached her. That's correct. And so, I told her, thank you. We would need the Coke back. And after that, we would need to go ahead and head to MARTA. And that's when it became a problem.
When you told her that you needed to head to MARTA, did you give her a criminal trespass warning at that time?
No, we gave her a criminal trespass warning once we didn't even get to that point. We gave her a criminal trespass warning once we got to the precinct. We never made it. The precinct and the MARTA station is right in front of each other. We never made it down the hall. We were on the other end of the airport. So all of that, all of everything that ensued occurred before that even took place. But she did get her criminal trespass as well. She did receive a trespass warning afterwards.
But that was at the precinct.
That's correct.
And by the time you got to the precinct, was she already under arrest at that time?
That's correct.
Okay. What was she under arrest for?
Those, I'll repeat the charges again: the shoplifting, disorderly conduct, and obstruction of a police officer.
Okay. So you didn't actually end up charging her with criminal trespass in this case?
No, there was no criminal trespass warning on file prior to this. So she officially has a criminal trespass warning now from the airport.
I got you. Those are the questions I have at this time.
Okay, any redirect?
No, Your Honor.
Okay. May Officer Shelley be released?
Yes, Your Honor. Thank you, Officer Shelley.
Thank you. I appreciate you guys taking that.
Thank you.
Okay. Does the defense intend on calling any witnesses?
No witnesses, Your Honor.
Okay. Any argument?
Yes, Your Honor. Your Honor, the state requests that the court find that there is sufficient probable cause for charges of theft by shoplifting, disorderly conduct and obstructing an officer against the defendant, Ms. Linda Walker. Theft by shoplifting, whereby the defendant, Ms. Walker, had taken a stolen bottle of Coke from a store within the airport. She did not have permission. She did not pay for that Coke. She just grabbed the Coke and fled from that incident location towards the shoe shine booth located within the airport. Furthermore, Your Honor, disorderly conduct, the state finds that there is sufficient justification for charges of disorderly conduct and obstructing an officer, whereby in this case, Your Honor, for disorderly conduct, Ms. Walker's actions did support a finding of fear within the officer, not only based upon her training, but also based upon the fact that the defendant began to utter that if the officer touched her, that she was going to fight the officer, one, and then actually acted on that threat by swinging her bag at the officer, grabbing the officer's duty belt, whereby both of them fell to the ground during that struggle and began to attempt to kick the officer upon being restrained by Officer Shelley and other officers that Officer Shelley had called to the scene, thus placing Officer Shelley in fear of, in reasonable fear of the safety of her person. And furthermore, the obstruction, Your Honor, as Ms. Walker was being escorted to MARTA, she obstructed Officer Shelley in the discharge of her lawful duties as an officer, Atlanta PD officer, when she began to combat Officer Shelley and other officers, thereby preventing her from being escorted to the MARTA station and ultimately obstructed her from being adequately detained initially without the assistance of the other two officers.
Mr. Little.
I'm sorry.
I'm sorry.
No, that's
Go
it.
ahead.
We're good. Thank you, Your Honor.
Okay, Mr. Little.
Your Honor, we'll rest on the evidence.
Okay. I'm going to bind these charges over to the State Court of Clayton County. I think the evidence does present an interesting issue where the officer testified that they were not intending to arrest Ms. Walker, and that she became combative. And one could argue whether escorting someone to the MARTA station is a lawful discharge of the officer's duties. But I'm going to bind it over. There are people far more intelligent than I that can figure this out. Okay. Is there any other case that needs to be called out of order, or can we go to the Marcus case?
Your Honor, while we're on this end within the calendar, with respect to the swinging matter, I've been notified that there is an officer conflict with respect to Officer Brian Gator. He has a training conflict and he'll be available on the 15th of February. However, Your Honor, at this time, the state is not ready to go forward due to this conflict.
Who's handling Angela Swinging?
That's my case, Your Honor. And we were prepared for a hearing this morning.
So are you objecting to this?
I would object, Your Honor, and I would ask for a dismissal for lack of prosecution.
Mr. Simeon, when
Yes, Your
did you get the notice from this officer about training?
Yesterday afternoon.
I'm gonna take that under advisement for now. And I will address it at the end of the hearing.
Yes, Your Honor.
Mr. Little, don't let me forget.
No problem, Your Honor.
Okay. So can we call the next case, Michael Marcus?
Yes, Your Honor.
Okay, this is going to be the case of State of Georgia versus Michael Marcus. He's charged in warrant number 2021 WA 21509 with committing the offense of criminal trespass. Mr. Simeon, you may proceed.
Yes, Your Honor. One moment, please.
Yes, sir. Hey, give me one moment. I need to go get some water.
Yes, Your Honor. Thank you.
Okay, I'm back.
It's ready to proceed. The state would like to call Officer Tyler Santos to the stand. Good morning, Officer Santos.
Morning, sir.
Can you please raise your right hand? Do you swear in the matter today to tell the truth, the whole truth, and nothing but the truth, so help you God? What was that response? I'm sorry.
I do.
Thank you. Good morning, Officer Santos. Do you mind stating and spelling your name for the court?
Name is Officer Tyler Santos. First name is Tylor. Last name is Santos.
Thank you. Officer Santos, with whom are you employed?
Clayton County Police Department.
And how long have you been employed with Clayton County Police Department?
About 2 years and 9 months.
2 years and 9 months. Are you post-certified?
Yes, sir.
And have you responded to incidents like these in the past?
Yes, sir, I have.
Now, the date in question, December 27th of 2021, it shows that you were dispatched to 1077 Battle Creek Road. And that's a fire station, correct?
Correct, sir.
Is that located here in Clayton County?
Yes, it is.
So who did you encounter when you frequented this fire station or responded to this fire station on this date?
Initially encountered the EMS personnel whom advised that Marcus Michael had approached them stating that he was battered at his residence by Keandre Lyons.
Got you. Did you speak with Mr. Marcus at all?
Yes, I did.
And what did he tell you?
He told me that he was at the residence with his girlfriend, Shakarda Lyons, and her sons. He got into a verbal argument with Shakara after having some drinks, and he got upset and broke the bedroom window. Then later, one of Shakara's sons, Keandre, walked in the room and asked him why he broke the window, and then punched Marcus in the face. Marcus then stated that he left the incident and walked down the street to the firehouse to seek help.
So, Mr. Marcus told you that the incident took place at another location, correct?
Correct.
And was that location 7393 Terra Boulevard, apartment 305?
7393 Terra Road, apartment 305.
Terra Road, excuse me, I'm sorry, Terra Road.
Correct.
And is that located in that was located here in Jonesboro, correct?
Correct.
Here in Clayton County?
Yes, sir.
Okay. And did you transport the defendant back to that residence?
Yes, sir, I did.
So when you arrived, did you speak with Miss Lyons at this location?
Yes, sir.
And what did she tell you, sir?
She told me that she was having drinks with Mr. Marcus. They got into a verbal argument. He got upset and broke her bedroom window. She then stated that she grabbed his backpack for him and she sent him on his way to cool down. And that's the last that she saw of him.
So she did tell you also that the defendant broke a window within that residence.
Correct. Her bedroom window, which she valued $100.
Got you. And the defendant also told you that he broke that window as well.
Yes, sir.
Now, did you happen to see the window at all?
Yes, sir. I attached a picture to my report.
And when you saw it, did it appear to be damaged?
It was shattered and there was broken glass on the exterior of the window.
Okay. No further questions. Thank you, Officer Santos.
Yes, sir.
Mr. Little?
Thank you, Your Honor. Officer Santos, when you made contact with Mr. Marcus, did he appear to be injured?
Yes, sir. He was bleeding from his mouth.
And that's when you encountered him at the fire station?
Yes, sir.
Okay. Did he appear to be intoxicated?
Yes, sir. Confused speech. I had to repeatedly repeat my questions to him. He was slurring his words.
And so it's at the firehouse when you first talked to him that he told you that he had broken the window?
Correct.
Okay. Did he tell you how the window got broken?
He said that he was in an argument with his girlfriend, and he said that he got upset and broke the window. He did mention something about a ladder. He didn't specifically state that he used a ladder to break the window, but there was a ladder right outside the bedroom window.
Okay. Was the ladder like on the ground or anything outside the window?
It was standing up at the time I got there.
Interesting. But he didn't explain how mechanically that window got broken.
He just stated he broke it.
Fair enough. Now, when you spoke to Ms. Lyons, did she also appear to be intoxicated?
She did appear to be intoxicated.
Okay. Did you speak to any other witnesses about what happened to the window?
I spoke to her son, Kelvin, I believe, Kelvin Lyons. He stated that he saw Mr. Marcus break the window. And when I asked him about how Mr. Marcus got his injuries, he also stated that he did not know that it did not happen at that residence.
Oh, really? Who said that?
Mr. Kelvin.
Kelvin said that the injury didn't happen in the residence. But you did take out a warrant for Keandre Lyons.
Correct.
Okay. And that is who Mr. Marcus told you attacked him.
Correct.
Okay. Those are the questions I have at this time.
Any redirect?
Oh, yeah.
May Officer Santos be released?
Yes, Your Honor.
Okay, sir, you released from today. Thank you for coming.
Thank you, Your Honor.
Is there any argument?
Yes, Your Honor.
Okay.
The state prays that the court finds that there is sufficient probable cause for a charge of criminal trespass against the defendant, Michael Marcus, in this case, Your Honor, whereby there was at the incident date in question, there was a verbal dispute between the defendant and the victim, Ms. Chicarda Lyons, whereby the defendant broke Ms. Lyons' bedroom window. Not only did Ms. Lyons mention this to the officer, but the defendant himself also admitted to breaking that window and valuing that window. The valuation of that damage was about $100, Your Honor. And the state humbly finds that based upon this, the testimony as provided by the officer, that you find that there's sufficient probable cause for a charge of criminal trespass against defendant Michael Marcus. Thank you.
Mr. Little?
Your Honor, as to this case, we will rest on the evidence.
Okay. I'm going to find the evidence is sufficient to bind this case over to the state court of Clayton County on the one count of criminal trespass. So let's move on to Mr. Michael. Or is it Cassie Marion Michael?
That's a female, Your Honor.
Okay.
Who would like to see, sir?
Last name Michael, first name Cassie, Cassie.
Yes, sir.
Mr. Simeon,
Yes, Your Honor.
on the matter involving Angela Swingen,
Yes, sir.
as I'm going to address it at the end of the calendar, but I may be looking at a bond reduction
You go through, but place the ball on that side when they come to the.
Yes, Your Honor.
as a way to resolve this issue. And Mr. Little, I'm gonna want you to have an idea in your head about what would be something your client can make?
That's for swinging, Your Honor.
Okay, this is going to be the case of State of Georgia versus Cassie Marion Michael. She's charged in warrant number 2021 WA 21670 with criminal trespass and warrant number 2021 WA 21671 with simple battery. Mr. Simeon, the floor is yours.
Thank you, Your Honor. This time the state would like to call Officer Damian Blakeney to the stand.
This is him.
Good morning, officer.
Good morning.
Can you please raise your right hand? In this matter, do you swear to tell the truth, the whole truth, and nothing but the truth? So help you God.
Yes, sir.
Could you please spell and state your name for the court?
Damian Blakeney. That's Damian DAMIAN. Blakeney BLAKNEY.
Thank you, sir. Now, with whom are you employed currently?
Clayton County Police Department.
And how long have you been employed with them, sir?
About 3 years.
About 3 years. Are you post-certified?
Yes, sir.
And have you responded to dispatches have you responded to similar dispatches in the past?
Yes, sir.
Now, the incident date, December 31st, 2021, you responded to the incident location of 6888 Mystic Lane in Morro. Is that correct?
Yes, sir.
Now, is that here in Clayton County?
Yes, sir.
Now, upon arriving on scene on this date, you made contact with Miss Holyfield. Is that correct?
Yes, sir.
Now, can you please explain to the court what that conversation consisted of between you and Miss Holyfield?
Pretty much, Miss Holyfield stated that her granddaughter, Miss Cassie, had physically assaulted her daughter, and that she was having a mental episode after not having her medication for the past 3 days. And once they had de-escalated the situation, her daughter had walked over to the Christmas tree and knocked it over, damaging several ornaments that was on it.
Okay, and you said you spoke to Ms. Holyfield and stated that the defendant, Cassie Michael, got into an altercation with Ms. Holyfield's daughter. Is that correct?
Yes.
And her name is Cassandra Michael. Is that correct?
Yes.
Now, is this Cassie's mother?
Yes.
This is Cassie's mother. Okay, thank you. So, Ms. Holyfield mentioned that there was a physical altercation between the defendant and her mother, defendant's mother.
Yes.
Did you make contact with the defendant's mother, Cassandra Michael, correct?
Yes, sir.
Now, could you explain how that conversation went between you and Miss Cassandra and what was stated then?
Miss Cassandra stated almost similar to what Miss Holyfield stated, that Casey was on her medication for the past few days, and while she was experiencing the episode of it, she started walking towards her grandmother, which Miss Cassandra stated she stepped in front of her, and that's when Casey started swinging her hand rapidly, striking her in the area of the face. After she was able to calm her down, Casey pretty much the same thing, walked over to the tree and just threw it over.
Okay, so you did mention that Cassie had she struck her mother in the face when she was swinging her arms, correct?
Yes, sir.
Okay, I'm sorry, her hands, and she struck her in the face. Is that correct?
Yes, sir.
Did you notice any markings or abrasions, bruising, scratches, anything to the face of Miss Cassandra?
No, sir. No markings.
And you mentioned that the defendant walked over to the Christmas tree and she just knocked it down, correct?
Yes, sir.
And you saw broken ornaments on the floor?
Yes, sir.
Did you notice any other damage caused by her knocking the tree down besides the ornaments?
It was some presents knocked over, but it wasn't damaged.
Okay. No further questions. Thank you, Officer Blakely.
Mr. Little?
Thank you, Your Honor. Officer, you spoke to Priscilla Holyfield regarding this case,
Yes, sir.
and that is Cassie Michael's grandmother.
Yes.
And Miss Holyfield told you that she thought Cassie was having a mental health episode.
Yes, sir.
She told you that Cassie's bipolar and paranoid.
Yes, sir.
Did she tell you that Cassie is schizophrenic?
Yes, sir.
And you also spoke to Cassandra Michael. That's Cassie's mother.
Yes, sir.
Cassie's mother also indicated that she is schizophrenic and had a mental episode.
Yes, sir. And Cassie stated the same thing. She had mental disorder.
And that's why they called for the police assistance.
Yes, sir.
Okay. Did you speak to any other witnesses there?
No, sir.
Were there any other people there?
It was a juvenile there, but she was holding the baby, and they didn't really want me to speak to her.
Okay. Did you speak to Cassie when she was arrested?
Yes, sir.
Did she tell you anything?
She was making it was kind of hard to really understand her because she kept jumping subject, pretty much about I'm gonna get in trouble for being there. Then she'll have another outburst of this yelling. So it was really couldn't get a good, strong statement from her. But I was able to pinpoint that she did say that she had issues.
Okay. So you had a hard time communicating with her.
Mm-hmm.
And did it seem to you like she was having a mental health episode?
It was, yes.
Okay. Those are the questions I have at this time.
Okay, I have a question for you, Officer Blakeney. Is there a procedure that is in place to take a person who's having a mental health episode
Yes,
to
sir.
a hospital rather than jail?
Yes, sir, for 1013, but due to the them not having space up there, they kind of like halted us for doing that.
Okay. I've heard estimates that there's as much as 40% of the people in the jail currently are people that have some kind of mental health issue.
Yes.
And I just
They normally used to allow us, but it was sometime I think in September that issue of emails telling most of us not to 1013 them because of some stuff that was going on.
okay. Okay. And I'm not blaming you. I was just seeking information. Does anyone have any questions based upon what I just asked Officer Blakeney?
No, Your
Not
Honor.
from defense, Your Honor.
Okay. May Officer Blakeney be excused?
Yes, Your Honor.
Thank you, sir. You're excused. Have a good day.
Y'all too.
Any arguments?
Yes, Your Honor. The state requests that the court finds that there is sufficient probable cause for charges of simple battery and criminal trespass. I'm sorry. Yes. Criminal trespass and simple battery, against the defendant, Ms. Cassie Michael, in this instance whereby, as the officer's testimony alluded, the defendant made unwanted physical contact when she started swinging her arms and struck her mother in the face and struck her mother in the face. And also with respect to criminal trespass, wherever she walked over to the Christmas tree, threw it on the floor and thus breaking ornaments on the tree, damage of which less than $500, Your Honor. The state, based upon the facts that's provided throughout the testimony of the officer, prays that the court finds that there is a sufficient finding of probable cause for charges of criminal trespass and simple battery against the defendant, Ms. Cassie Michael. Thank you.
Thank you, Mr. Little.
Thank you, Your Honor. Both criminal trespass and simple battery require the defendant acting intentionally. In this case, Your Honor, Cassie's grandmother, Cassie's mother, all indicated that she has schizophrenia. She's had some trouble with her medication, and it seemed as though she was having a mental health episode at the time. Officer Blakeney, when he talked to Cassie, said that she was changing rapidly from one subject to another, and it seemed to him as though she was also having a mental health episode. Your Honor, this is not a criminal case. This is a case of someone who, because of the mental illness they have and the difficulty they were having with the medication dosage they were on, was unable to control themselves. And Your Honor, I would argue that the state has failed to meet their burden of probable cause because they aren't able to show that Cassie was acting intentionally during this incident.
There is a case, Mr. Little, out of DeKalb County, and I can't remember the name now, but it's a case that basically holds that a person who has been diagnosed with a mental illness and told to take their medication, that they cannot use as an excuse the fact that they were not on their medication at the time of the incident. I agree with you that that was something that is arguable. And I thought about it when I was listening to the officer's testimony. But at this point, I'm going to find that there is sufficient evidence to bind this case over to state court. It does not bring me any joy in doing this because I do believe that as a society, we are failing people that have mental illness. And I think the current state of the law is one that doesn't address the fact that there have been advancements made in medical treatment so that we're not just at a point where we err on the side of placing people in jail rather than getting them help. I understand your argument, but I have to do what I think I'm required to do at this stage. And I'm waiting for the day that there's a mental health court and state court here in Clayton County to address these issues, because I think it handcuffs too many people on both sides who are trying to do the right thing with what we have now. So this case is going to get bound over to state court.
Thank you, Your Honor.
Well, it says it's a fast track superior court for Judge Mack.
Is that what it says on the calendar, Your Honor?
Yeah.
Because I think on the calendar, they just print that on a lot of the cases that they have fast tracks, but I don't see how it could go to superior court if she's charged with misdemeanors.
Yeah, I don't know. I honestly do not know. But we're gonna send it over to state court. I guess this will be another case. We're getting emails about it not being bound over. All right, the next case is Sanders.
It's also my case, Your Honor.
Okay, Nicole Christina Sanders. We have Officer Jordan.
I'm here.
One moment, Your Honor. We're still waiting for the defendant. Never mind. Excuse me.
Sure. Okay, we have Miss Sanders present.
Yes, sir.
And this is going to be the case of State of Georgia versus Nicole Christina Sanders, charged in warrant number 2021 WA 21407 with committing the offense of battery. And whenever you're ready, Mr. Simeon, you can proceed.
Thank you, Your Honor. Your Honor, say we'd like to call Officer Thomasina Jordan to the stand.
I'm here.
Good morning, Officer Jordan.
Good morning, sir.
Could you please raise your right hand for me? In this matter, do you swear to tell the truth, the whole truth, and nothing but the truth? So help you God.
Yes, sir.
Thank you. Officer Jordan, could you please state and spell your name for the court?
My first name is Thomasina, Thomasina. Last name is Jordan, Jordan.
And with whom are you employed?
The Morro Police Department.
You said Morro Police Department?
Yes, sir.
Thank you. I apologize. No, is that located here in Clayton County?
Yes, it's located in the county of Clayton.
Thank you. Are you post-certified?
Yes, I am, sir.
And how long have you been employed with Morro Police Department?
11 months.
11 months. Now, have you, is this your first stint in law enforcement?
No.
Where were you employed prior to Morro, or where else have you been employed as a police officer?
In Powder Springs, I did a year there, and I also did 25 years in New York City.
Thank you. Have you responded to incidents like this in the past?
Yes, I have.
Now, on the date in question, I want to say it was December 24, 2021. You responded to a Red Roof Inn at 1348 South Lake Plaza Drive in Morro. Is that correct?
Yes, sir.
And was that incident location here in Clayton County?
Yes, it was in Morro in the county of Clayton.
Thank you. Now, you met with the victim, Ms. Bynum. Is that correct?
Yes, I did.
Now, could you please state to the court what Ms. Bynum told you?
Ms. Bynum told me that she was staying in room 134 in the Red Roof Inn.
Yes, ma'am.
She said that she went to room 240 where her friend Marcus Shelton was staying. And she went to the room to give him a fish sandwich because he had given her fish 2 days before. While she was knocked on the door, she was giving Mr. Marcus the fish sandwich. A female who was staying in the room with him came from behind him and proceeded to punch her in the face. She ran back downstairs to her room and she called 911.
And when you, and thank you, when you were talking to the victim, Ms. Bynum, did you see any physical manifestations of the defendant striking Ms. Bynum in the face? Did you see any bruising, any scratching, any abrasions, anything like that?
Yes, I did. There was significant bruising to the right side of her face by her temple area, by her eye, and her right cheek.
Okay. And did you also speak with the defendant, Ms. Sanders?
Yes, I did.
Did she admit to striking the defendant in the face? I'm sorry, did she admit to striking the victim in the face? Excuse me.
Yes, I went to room 240 because that's the room Ms. Bynum told me the person that attacked her was staying at. I knocked on the door. Ms. Sanders came to the door and Ms. Bynum was standing behind another officer. I asked Ms. Sanders what happened, what occurred. And she stated an incoherent statement. She said that, asked her what happened. She said that she works for the CIA and she's allowed to attack spies. I didn't really know what that meant. So Ms. Bynum was standing behind another officer, which was Officer Fortune. I asked her, is this the person who attacked you? She said yes. I asked her, do you want to press charges? And she said yes. And then I placed Ms. Sanders under arrest.
Thank you, Officer Jordan. Your Honor, no further questions.
Mr. Little?
No questions, Your Honor.
Okay. May Officer Jordan be excused?
Yes, Your Honor.
Officer Jordan, you're excused. Thank you for your presence. Have a good day.
You too, sir.
Any arguments?
Yes, Your Honor. The state requests that the court finds that there is sufficient showing sufficient showing based upon the testimony of Officer Jordan for a charge of battery against the defendant, Nicole Sanders, in this case, whereby the testimony revealed that the defendant struck the victim, Ms. Carla Bynum, in the face with a closed fist and caused substantial bodily injury, i.e. bruising, to the right side of Ms. Bynum's face. This was corroborated by Ms. Bynum when she confirmed the identity of the defendant at the scene of the incident, Red Roof Inn in Morro, Georgia, in Clayton County. Again, the state prays that the court finds that there is substantial justification to show to warrant a charge of battery against the defendant, Nicole Sanders.
Mr. Little?
We'll rest on the evidence, Your Honor.
Okay. Based upon the evidence provided, I find that there is sufficient evidence for this case to get bound over to the state court of Clayton County. So that would be the ruling of the court. Let's move to Mr. Shobe or Shobi with Mr. Suh.
Yes, Your Honor. Mr. Shobe.
Shobe.
Shobe, yes, sir.
Okay. You know, the hardest thing for a judge to do is to call a calendar. I'll have discussions with my wife about how to pronounce a certain name, just because I'm trying to do it right. Okay, so this is going to be the case of State of Georgia versus Aaron Shobe. He's charged in warrant number 2021 WA 21635 with possession of marijuana less than an ounce. He's also charged in warrant number 2021 WA 21636 with contributing to the delinquency or deprivation of a minor. Mr. Simeon, you have the floor.
One moment, Your Honor, please.
Yes, sir.
Thank you, Your Honor. At this time, the state would like to call Officer Janice Sutton to the stand.
Present.
Oh, I'm sorry, I didn't see you there. Good afternoon, Officer Sutton.
How you doing?
All righty, so do you mind raising your right hand for me? In a matter before you today, do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Thank you, Officer Sutton. Do you mind stating and spelling your name for the court?
Officer Janet Sutton, JANET SUTTON,
Thank you. And with whom are you employed, Officer Sutton?
Clayton County Police Department.
And how long have you been employed with Clayton County Police Department?
About 3 years and 4 months.
And are you post-certified?
Yes, sir.
Have you investigated or responded to matters like this in the past?
Yes.
So on the incident date in question, December 30th of 2021, it appears you responded to 2070 Lake Harbin Road in Morro. Is that correct?
Yes,
And is that here in Clayton County?
it is.
Now, you received, was this an anonymous tip that you received about the defendant?
Basically, one of the residents at the apartment complex called in and stated it was a suspicious male walking around her apartment building M, and that the male was sitting in the vehicle, in a black vehicle with dark tinted windows.
And did the defendant live there?
He did not.
He did not. So upon making contact, I'm assuming you walked up to the vehicle, correct?
Correct.
And did you smell anything as you were approaching the vehicle?
Yes. When we pulled up to the building and observed the vehicle, the defendant rolled down the window. We seen a plume of smoke. As we approached the vehicle, we could smell the strong odor of marijuana emitting from the vehicle.
And as you said, as he rolled down the window, there was a plume of smoke that was released, correct?
Correct.
And now, did you further confirm that you had smelled marijuana before, and that was, I guess, the source of that smell?
Yes.
Now, when you saw the defendant, was he in the driver's seat?
He was, yes.
Did you notice anything regarding his clothes, anything regarding his appearance?
He had little droplets of marijuana residue on his clothing, pants, and his shirt.
I'm sorry, and you could visibly see that from outside of the window.
Correct. Standing at the window.
Did you ask, was there anyone else in the vehicle at that time?
Yes, it was a juvenile in the passenger seat.
And how did you notice this person was a juvenile?
I didn't know it until further investigation after speaking with the juvenile.
And did he have an ID? Did he provide you with any information that could confirm his status as a juvenile?
Yes, he didn't have an ID on his person at the time, but he did give me his name and date of birth, which I later ran in GCIC, and his information came back.
And it confirmed that his identity of Gabriel Davidson?
Yes, sir.
And that he was a juvenile?
Yes.
Was the defendant, is the defendant a juvenile?
No.
No. So did you, what occurred next?
While speaking with the defendant, he was asked if he lived in the complex, and he stated no, he didn't currently live there, that he was homeless, but that he used to live in the complex and he has friends in the complex.
Okay. And did you conduct upon smelling that odor of marijuana, seeing the residue on his clothes, and seeing that plume of smoke come from the vehicle as he rolled down the window, did you conduct a search?
Yes, a search of the vehicle was conducted, and marijuana was located near the radio, right up under the radio in the little pocket near where the radio is, basically, in the little coin pocket up under the radio.
Okay. You found marijuana there, correct?
Yes.
Did you search his person?
Yes. Mr. Davidson was patted down for weapons. No weapons were located, but marijuana was found in the vehicle. On the juvenile defendant, while patting him down, I did notice it was a bulge in his pocket. When I asked him about it, he stated, I think it's weed, but I don't know which pocket it's in.
And did you continue with that search?
Yes, at that time I did retrieve a clear bag containing marijuana out of his left pant pocket.
And sorry, you said you did find the marijuana in Davis's left pants pocket.
Correct.
Did the defendant admit to smoking marijuana?
Yes, while on scene, he did admit that, he was just there smoking marijuana in the vehicle.
Got you. Thank you, Officer Sutton. Your Honor, no further questions.
Mr. Suh?
Thank you, Your Honor. Hello, Officer Sutton.
How you doing?
Let's see now. Just a few questions. First question, you said that you saw droplets of marijuana. Could you better describe what you mean by droplets?
Well, just loose marijuana residue, just pieces of marijuana that was dropped on his clothing.
Loose pieces of marijuana. Okay. And just to confirm, you found this weed under the radio in one location?
Correct.
I was just going to rapid fire. And also you found some weed on the juvenile?
Correct.
And those are the only two places?
Right.
Okay, under the radio and on the juvenile, okay. Now, you also charged the accused with aiding in the delinquency, let me read it, contribute to the delinquency or deprivation. Could you be more specific? What exact act are you basing that charge on?
I charge him with contributing to the delinquency of a minor. He's not related to that minor. However, they were in the vehicle smoking marijuana together.
Okay, so just to confirm, it's the smoking of the weed which was the basis on
the delinquent act. Yes.
Delinquent act, okay.
Delinquency. Mm-hmm.
And nothing else?
No, that's it. That's the only thing I charge him with.
Thank you, officer. No further questions.
Any redirect?
No, Your Honor.
May Officer Sutton be released?
Yes, Your Honor.
Officer Sutton, you're released from today's hearing. Thank you for appearing. Have a good day.
You as well, sir. Thank you.
Any argument?
Yes, Your Honor. One moment, if you don't mind. Your Honor, the state requests that the court find there is sufficient probable cause based upon the testimony of Officer Sutton for charges of possession of marijuana of 1 ounce or less, as well as contributing to the delinquency of a minor against the defendant Aaron Schob, whereby in this case, Your Honor, the officer testified that as she responded to the suspicious person call and saw, based upon the information the tip provided to her, that the defendant was located in the vehicle that she approached, she did smell an odor of marijuana. Upon rolling down the window, she did see a plume of marijuana smoke be released from that vehicle. She did identify, upon seeing that plume and smelling that scent of marijuana as she approached the vehicle, as that vehicle and defendant being the source of that smell. But she also saw, as she mentioned, the droplets are physical, I guess, pieces of marijuana residue on the defendant's clothes. She also, upon conducting a search of the vehicle, found the marijuana, she said, near the radio, in that little compartment near the radio. But also, Your Honor, to support a charge of contributing to the delinquency of a minor, there was a minor in that vehicle, Gabriel Davidson, who was engaged in smoking marijuana with the defendant in this case. Gabriel Davidson is or was 16 at the time of the incident. A delinquent act being in possession of marijuana of less than 1 ounce, whereby upon a search of his person, there was marijuana in his left pants pocket, and he thereby said, "I think it's weed, but I don't know which pocket it's in." When the officer searched that pocket, they discovered a bag and a clear bag in Mr. Davis's pocket of 4.3 grams of marijuana, and the defendant showed based upon his smoking of marijuana and him having marijuana in his possession in his vehicle, could be said to have knowingly and willfully encouraged, abetted, and or aided the minor, Mr. Gabriel Davidson, in committing the delinquent act. The delinquent act being the possession of marijuana in the amount of 1 ounce or less. The defendant also admitted to the officers that he was sitting in the car smoking marijuana at the time. It is for these purposes and these facts and these reasonings, Judge, as provided by the officer's testimony, that the state requests that the court find that there is sufficient facts to support a finding of support charges, of possession of marijuana of 1 ounce or less, as well as contributing to the delinquency of a minor, Mr. Gabriel Davidson, against the defendant, Aaron Scholl.
Mr. Suh?
Thank you, Your Honor. Your Honor, although this case raises great concerns in my eyes, and I fear about the efficiency of the court and the costs related to such things, but considering that today we're here for the preliminary hearing and considering the narrow scope of the purpose of the preliminary hearing, we'll go ahead and submit on the evidence and raise our concerns at a later date.
Okay.
Unless, yes.
I'm sorry.
Oh, please, yes, go ahead, continue, Your Honor. That's all for me.
Okay. Well, I find that the evidence is sufficient to bind it over. I do have concerns about the contributing to the delinquency or deprivation of a minor, but I believe Mr. Simeon cleared that up with his questioning of the officer. So this case will get bound over to the state court of Clayton County. Next case I have is Stevens.
Mr. Honor.
And believe that's your case also, Mr. Suh.
Yes, Your Honor.
We need John Eric Stevens. Okay, it looks like we have Mr. Stevens present. When you are ready, Mr. Simeon, well, let me call the case, and then when you're ready, sir, we can move forward. This is going to be position 18, State of Georgia versus John Eric Stevens. He's charged in warrant number 2021 WA 21633 with driving under the influence of alcohol to the extent that he's a less safe driver. And he's charged in warrant number 2021 WA 21634 with obstructing an officer. And when you're prepared, Mr. Simeon, we can begin.
Thank you, Your Honor. One moment, Your Honor.
No problem.
Your Honor, this time the state would like to call Officer Eric Thomas to the stand. Good morning, Officer Thomas.
Morning.
Could you please raise your right hand? In this matter before you, do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
I affirm.
Thank you. Could you please?
Mr. Simeon, I was just gonna interrupt and say,
Yes, sir.
technically now we're in the afternoon.
Thank you, Your Honor. Good afternoon. I apologize. Thank you, Your Honor. I've been at this for a minute, so excuse me. Do you could you please, Officer Thomas, could you please state your name and spell your name for the court?
My name is Eric, E-R-I-C, last name Thomas, T-H-O-M-A-S.
Thank you, Officer Thomas. With whom are you currently employed?
Clayton County Police Department.
And are you how long have you been employed with Clayton County Police Department?
2 years.
2 years?
2 years.
Are you post certified?
I am.
Are you SFST certified?
I am.
Are you ARIDE certified?
I am.
At the time of this incident, were you certified in all, did you have all 3 of these certifications?
I did.
So let me back up. Could you please explain to the court what SFST certification corresponds with?
Standardized field sobriety test. It's a couple of exercises you use to test the impairment of an individual who have been under the influence of alcohol.
And what about ARIDE certification?
ARIDE is Advanced Roadside Impairment Driving Enforcement, which tests the impairment of a person who or individual using a drug impairment up under the influence.
Okay, thank you. So you responded on December 30th of 2021, you responded to 6990 Terra Boulevard in Jonesboro, correct?
Correct.
Now is that here in Clayton County?
It is.
And that appears to be a location of a Toei Tires. Is that correct?
Yes.
You said you received a dispatch, or how were you alerted to this location, sir?
I was watching my screen. I see a drunk person came out at the business. So I just clicked on it and I went to it.
And when you arrived on scene, well, did you speak with this anonymous caller at all?
I did. He was standing outside waiting on me.
Gotcha. And when you encountered the caller, what did he tell you?
He told me that this guy, Mr. Johnston, had pulled up and he had been drinking inside his car. And he pulled up, he was being very aggressive towards him. And he said he wasn't going to help them until he calmed down.
And did the defendant in this matter, Mr. Stevens, appear calm when you interacted with him?
When I interacted the first time, yes.
The first time he was?
First time he was, yes.
And what else did the caller observe the defendant doing?
He was drinking inside his car. He pulled up drinking.
So when you arrived and after speaking with this caller, did you speak with the defendant?
I did.
And what did the defendant tell you?
He kept asking me what did the anonymous caller kept telling me what to say, and I like, I'm asking you. I'm here to get both sides of the story. He told me can he get his service done to his vehicle, and after that he was gonna leave.
Okay. And did you smell any alcohol on his person, on his breath?
I did smell alcohol on his person, his breath.
Did you ask him if he had anything to drink?
I did. He said he had one mixed cocktail, one mixed drink, around about 20 minutes prior to showing up to that location.
So he said 20 minutes prior to arriving at this location, he had an alcoholic beverage.
Yes.
And did he state that after consuming this alcoholic beverage that he began to drive his vehicle?
Correct. He drove his vehicle to the Toy Tires Company right down Tara Boulevard.
Gotcha. Now, at this point, did you find that there was sufficient probable cause to conduct a DUI investigation?
Yes, due to the odor of an alcoholic beverage coming from a birthing person, I did ask him, you mind if I check his eyes to make sure he was safe to drive?
So at that point, you began your standardized field sobriety test. Is that correct?
Correct.
Did he consent to conducting these tests?
He did consent.
And did he state that were there any medical conditions that would have prevented him from conducting these tests?
Not that I know of, no.
So what's the first test that you conducted?
The horizontal gaze and the Stagnant test.
All right. Did you confirm that he didn't wear any glasses or contacts or have any type of medical conditions as it relates to his eyes?
Yes, I did.
And did he wear glasses or contacts?
He was not wearing glasses or contacts.
And did he have a medical condition to his eyes that would have prevented him from conducting the horizontal gaze and Nystagmus test?
No, sir.
All right. And did he consent to this test, the horizontal gaze and Nystagmus test?
Yes, sir.
And you instructed him on how to perform this test, correct?
Correct.
And what did you observe?
I observed him do it multiple times. I told him just to follow the tip of my finger with his eyes and eyes only, and he was not following that instruction. So I stopped and tried to have a cordial conversation with him, see how much, just to go back on how much he had to drink. See, was he going to reiterate the same thing again that he told me the first time?
Gotcha.
So then I went back into the horizontal gaze and Nystagmus, and he still did not follow the stimulus with his eyes and eyes only.
Got you. And did how many clues are needed to support a finding of probable intoxication?
4 out of 6.
And you found how many?
4 out of 6.
Got you. Can you detail what those findings, what clues that you observed?
The lack of smooth pursuit, distinct and sustained Nystagmus at maximum deviation.
And did you observe his eyes at rest?
His eyes did not have rest in Nystagmus, no.
Thank you. So you observed 4 out of the 6 clues to support a probable positive finding of impairment.
Correct.
Next, what was the next test that you conducted?
The walk and turn test, but this test got a little difficult because he said that he kept reiterating, I don't have to do him like this. I don't have to treat him like this. So therefore, I took it as he didn't want to do that either. He didn't want to do the walk and turn. He didn't want to do none of the other stuff. So I took it that he didn't want to cooperate.
Did he attempt to conduct the test? Did he attempt to complete the test at all?
I put him in the instructional phase where you got to place your left foot and then place your right foot heel to toe and stand up until I tell you to move. And he said he understood and he moved. After that, I demonstrated the instructions for him. Then he said, I'm not going to do all this, man. You got me tripping. I'm tripping.
So you weren't able to complete that test for that reason?
I was not able to complete that test because he was not cooperative.
Got you. And is it safe to assume that you did not conduct the one-legged stand at all?
No, sir, I did not conduct that.
Was that for the same reason?
Yes, sir, it was for the same reason.
And what occurred next?
What occurred next, I told him to turn around and face my car. And I told him to place his hand on my hood and spread his feet. I told him I placed him on the wrist for the DUI.
And how did he respond to that?
He was just being like, I'm not drunk. I was not driving. You didn't pull me over. I said, it's not about how I put you in the fact that you drove your vehicle using physical control of your vehicle. You had a drink, you drove here. So therefore, at one point in time, you did consume alcohol beverage before entering the roadway and you drove here.
And did you read him imply consent for individuals over the age of 21?
I did read implied consent, and he said, "You get this shit out of my face, man. You get this shit out of my face. I don't hear nothing you got to say. You get this shit out of my face, man."
And did that, I guess, allude that he refused the
Yes,
implied
he
consent? I'm sorry, let me back. What did you read implied consent for? What did you request?
For the blood.
For blood, and he refused, correct?
He did refuse, yes.
How did you know he was over the age of 21?
Guys, I asked him, I confirmed with his ID in my hand. I asked him, "Are you over the age of 21? And I asked for his date, for his date of birth. He's telling me, "Get this out of my face." He never wanted consent to give me his age.
Got you. Now, when you arrested him, placed him in the back of the vehicle, the patrol vehicle, did he say anything to you?
He was being very derogative. He was getting very upset when I started to kick the cage. Just starting getting very derogative.
Do you mind stating for the court what he said?
He said, "You're a bitch ass nigga. You're a faggot. You got a dick stuck up your ass. All this, that, and the third. I'm not drunk. You can take the handcuffs off me. I'm not doing all this. I'm not drunk. I wasn't driving my vehicle." He went the full shebang.
Did he damage your vehicle at all?
When I went back and looked at the body, my in-car camera, when he was kicking the inside of my cage, for the moment period of time when you see on the in-car camera, it stopped working for a brief second. Then it froze at the end, and you can't see where he further kicked it some more because it froze. But now my computer, my in-car camera is back working.
Gotcha. Now, did you, despite his refusal, did you obtain a blood search warrant to procure his blood?
I did. I obtained it from Judge Bandu.
Okay.
Bandu.
And did you, and what occurred next upon informing him that you obtained a search warrant for his blood?
I took him to the Clayton County Jail, and I was going to get the blood search warrant. And then when I gave him to the nurse, turned him over to the nurse, he talking about, "I'm not giving my blood." And the nurse wasn't going to stick him, so I charged him with obstruction. He said he wasn't giving blood. Even if the judge signed the order off on him, he still was giving his blood. So I charged him with obstruction.
Thank you, Officer Thomas. Y'all no further questions?
Mr. Sell.
Thank you, Your Honor. Okay. Oh, officer, bear with me for a little bit. We might be here for a couple minutes. I want to start with a couple of your comments just to get this out of the way. Let's go in reverse order. I wasn't driving my vehicle. That is what you indicated the accused stated at the jail. Is that correct?
Yes, that's what he stated.
Okay, so he's saying that he's not driving his vehicle, but in your police report near the beginning of your investigation, I'm going to read this to you if you could just confirm whether this is your statement or not. Stephen admitted to operating a 2001 Ford Explorer on Terra Boulevard after drinking the cocktail beverage. Is that your statement?
Say it again. You cut off, Mr. So.
Sure. Paragraph number 2. If I would ask you to just, do you have your police report with you?
I do. I'm reading it right now.
Excellent. If you go to, I think this on this first page of the narrative section, 4th paragraph, the last sentence. If you could just read that.
Where it says Stephen stated he attempted to get back in his vehicle.
I'll just read one more time. Stevens admitted to operating a 2001 Ford Explorer on Tyler Boulevard after drinking the cocktail beverage.
Gotcha. I see it.
Okay. Now that is your statement, correct?
Yes.
Could you explain, is it possible that he might have said Stevens admitted to operating 2001 Ford Explorer on Terra Boulevard and drinking the cocktail beverage by changing one word? Is that not possible?
That's not possible. He said that he drank the cocktail before he got on the roadway.
Is this the same cocktail he said that he drank 20 minutes before your arrival?
That's the same cocktail he said he drank 20 minutes prior to my arrival. Yes.
And so, do you know why he was at this location? Like, what was his purpose of being at this Towie Tower tires?
He was at a tire shop to get an oil change and stuff like that in third, but that's a tire shop. Tire shop does oil change. They don't change tires.
But he was there to get some work done on his car?
I'm assuming so. Yes, sir.
Okay. Did you by any chance talk to any of the employees inside of the Toei Tires?
I don't talk to the person that called 911. He wanted to stay anonymous the whole duration.
So you never talked to the actual, okay. So you're not aware that,
I just talked to the person.
so you're not aware of any conversation that occurred
Say it again?
between, you're not aware of any conversation that occurred between the accused and the, I guess, agents of Toei Tires?
No, I just talked to the person that called 911. He's the one that called and led the crime.
Now let's just confirm a few more things. The anonymous caller did state that he saw Mr. Stevens drinking in the parking lot. Is that correct? Second paragraph.
Correct.
And he said the entire time. Is that correct?
Correct.
Now, at no point does the anonymous caller indicate he ever saw Mr. The accused driving. Is that, did he never say anything of that nature?
He did. He said he pulled in. He pulled into the place and parked his car there. He was drinking alcoholic beverage.
So I'm just asking because it seems to be a little bit confusion. The report says he saw him drinking in the parking lot. It doesn't say anything about him driving in, seeing him, or anything of that nature. But that is what you're testifying today?
Yes, that is what happened. It's on body camera.
Okay. All right. So anonymous, but could you tell us anything about this anonymous caller? Like, was he actually a pedestrian, an employee, anything to help us understand his?
Was an employee working on, he was actually changing somebody else's tire. He was there working. He was a Hispanic male, there working, trying to make a living. And the guy came up, Mr. Stevens came up, being aggressive towards him. He didn't like, so he called 911.
Now, also, I believe Mr. Stevens indicated that his keys were locked in the vehicle. Did you, were you able to confirm that the keys were in fact locked in his vehicle?
His vehicle still running. We walked over to his car to drive side. I said, let's see, can we unlock the vehicle? His door handle was broken, so his doors were locked, so he could not get back inside his vehicle.
But did you, let's jump a little bit. During the arrest, did you do an inventory search of the accused person, his body?
I couldn't do inventory search because therefore the vehicle was locked. I couldn't get inside the vehicle.
Oh, I'm sorry. Did you do search the accused, Mr. Did you search Mr. Stevens?
I did, sir.
Did he have any car keys on his body at that time?
No, sir. He only had his wallet and cell phone.
Were you able to confirm that the keys were in fact locked in the vehicle?
The key was in the ignition because the car was still, the truck was
They
still
were in
running.
the ignition. Okay. I'll move on to my next set of questions after I just ask, I believe, one more. At any point, did you visually see Mr. Stevens driving his vehicle, regardless of intoxication or not just driving? Okay.
No, sir. I never see him drive his vehicle.
I want to move on to the obstruction aspect. Now, let me just confirm. Did you charge him with obstruction when he failed to provide his blood during the course of this process?
I charged him with obstruction when he didn't want to give his blood after it was signed by a judge.
Okay. So just to confirm, the obstruction charge is based on his refusal to give blood based on the order of the judge. Now let's give a time frame from the moment you received the phone call to the moment you arrived. The moment you've received the anonymous call and the moment you arrived. About how much time elapsed between that period?
I could really say, I'm gonna give a guess from them 30 to 45 minutes. That's all I can really say.
So the time that
when the call probable.
The call came in to the moment you arrived.
When the
about
call
30.
probable. Yes, sir.
Please continue. Sorry. Go ahead.
No, you're fine. 30 minutes. Yes, sir.
That is all the questions I have at this time, Your Honor.
Any redirect?
No, Your Honor.
Okay. May Officer Thomas be excused?
Yes, Your Honor.
Okay, Officer Thomas, you may be excused. I do have questions about the obstruction charge. And so I don't know if you may want to hold on to maybe help Mr. I'm sorry, Mr. Simeon. I do apologize, sir.
One moment, Your Honor.
Okay. So my question, and I'm opening this up to the forum, and both sides, please respond. After Officer Thomas obtained the warrant for the blood draw, was there any obligation from Mr. Stevens to participate in that?
As a lawful request from a judge, Your Honor?
Yes, sir.
1 second.
Wouldn't it be more than a similar in a contempt kind of realm other than obstruction? Yes, Mr. Suh.
If I may, I was going to indicate that's my understanding that blood is considered or taking of blood, it's my understanding that that's considered a search and requires special constitutional, I guess, considerations. With that said, I don't believe even if a judge orders it for blood draw purposes, that can be obstruction, because considering that, in addition, it's my understanding that when it comes to the consent laws, the accused has the option to decline blood test, and there's separate potential penalties associated with that. And it's my understanding that that should be made aware to all accused once, which is the purpose of the implied consent statements that are always read. So with that said, I was going to submit as part of my closing that obstruction, I don't believe there's not sufficient probable cause for that specific charge of obstructions to apply to the circumstance.
Yeah, I think Officer Thomas did what he was supposed to do, which is to get a search warrant. And the search warrant doesn't, and my understanding, doesn't necessarily obligate Mr. Stevens to submit to it. So
I'm sorry.
Go ahead, sir.
I apologize, Your Honor. So in Divey State, is a ruling from the Georgia Court of Appeals, 114 Georgia Appellate 299. The overview mentions that defendant's conviction for obstructing legal process was proper where the evidence showed that defendant knowingly and willfully obstructed an officer seeking to aid in the execution of a search warrant.
Okay.
Your Honor, I would submit that I can differentiate that very easily. A search warrant can be considered home, can be considered your car, can be considered many, many things. Whereas we're talking about blood, which is personal property, and I do believe is has a heightened sense of consideration when it comes to personal property like that.
And I would agree with defendant that it is blood is also considered personal property, but so is a home and the belongings therein. A search warrant is a search warrant. I believe if there is a conflict or any type of controversy regarding this issue, I believe that further supports this matter to be bound over to state court for resolution.
If I could just adjust, it wasn't to say personal property, a protected personal right. That is what I meant. I believe it, Stephen, you can jump in, but I believe there was a case recently that said blood is also.
I believe that was urine.
Sorry, Your Honor, kind of operating off the cuff right now.
No. Look, listen, I'm clear on the DUI issue. The obstructing issue is one that I'm having a concern with. And it's just about which it wasn't the point of the testimony. But let's say that there's some kind of religious right that Mr. Stevens has. that is preventing him from submitting to the blood draw. I don't believe the current state of our law is that his religious right to refuse the blood draw is trumped by the signature of a judge saying that you must submit your blood. And I know that's not the state of the evidence that we have here today, but that's the question that sort of the area where I'm kind of trying to muddle through. Mr. Little?
Your Honor, really my thoughts on this are, if there's a warrant that allows the police to collect evidence, that doesn't place an obligation on a defendant to then provide them with that evidence. A defendant always has the right to not participate in their own prosecution. They have their Fifth Amendment right not to incriminate themselves. When the state has a warrant, it's their duty then to execute that warrant and collect the evidence. It'd be like if you have a warrant to search someone's house, when you arrive at the house, they don't then have to, welcome you in. The police can enter into that house using the warrant that they have. And that's why oftentimes warrants have to be signed, because defendants don't give their consent in order to search their property or to take evidence from them.
And if those warrants can be executed due to the refusal of a defendant or suspect in that matter, then there are legal charges for that.
Let me ask you this question, Mr. Simeon. Let's use Mr. Little's
Yes, Your Honor.
hypo.
Yes, Your Honor.
The officer gets the warrant, and so the officer has legal justification to enter into the home. If the homeowner locks the door, let's say, and the officer then uses a battering ram to come through the door, is the homeowner subject to being charged with obstruction?
Without pulling any case law off the top of my head, Your Honor, just reading state laws, the laws provided by OCGA, yes, because that officer is lawfully trying to execute his duties and is being prevented to do so. That warrant from the court provides that officer with legal support or legal justification based upon the facts, circumstances, any totality of the circumstances, if you will, which supports that affidavit to conduct a search or arrest of any person pursuant to the issuing of that warrant. My understanding. Again, I'm not looking at case law to support that right now.
No, I know just from being a magistrate judge, it's a lot of times it's a one-sided affair, with the officer swears to certain facts and the officer informs the judge of those facts. And that's what the judge is operating on when signing a warrant. This is one that I've never experienced before. This is stumping me right now on the obstruction, as it relates to getting the warrant. I mean, Officer Thomas did what he was supposed to do, to go get a judge to sign off on the warrant. The judge signed off on the warrant. I know, as it relates to medical records and things like that, you got to get a search warrant from the hospital. You can't just go subpoena that information. In the case you cited, Mr. Simeon, was 114 Georgia Ave 299.
Yes, sir. I believe that's DYEV State. And that was just, I believe, Mr. Suh, as he distinguished, that was regarding property. That was a case regarding property. However, the ruling was that if the officer could not, was prevented from conducting a lawful search pursuant to the issuing of a lawful search warrant by a judge or whomever, then that defendant could be charged with obstruction.
Okay. Well,
Your Honor, if I could just add one case, I don't know if this is, since this is a different court, it's Missouri versus McNeely, a Supreme Court case.
Okay.
To bring the court's attention. In that case, although it's a different state, that court indicated that, hang on one second, please. And this was specifically in regards to blood being drawn for the purpose of testing blood alcohol content. And in this case, the court indicated that it would the removal of blood from the body would be equivalent to a search, where the Fourth Amendment rights must be considered. And thus raising this more higher than to the level of a fundamental right, I believe.
And Your Honor, the state could support that, one, by stating that's not controlling, but two, if it does give rise, I'm not saying if, but as defense counsel mentioned, that ruling provides, I guess, a further Fourth Amendment protection. The state would argue that the officer satisfied that by obtaining a warrant due to the totality of circumstances. If we would allow any additional time to, and again, we didn't get the blood, but if additional time elapses, there's potential for that evidence to just be erased as it travels through as blood travels through his system.
I understand the argument that you're making. As it stands, I'm going to allow this charge to move forward. I'm basing it on an argument that Mr. Simeon made with respect to this Dye versus State case. I'm going to review it, and I may have some objections later, but as it stands right now, I'm going to bind both charges over to the state court of Clayton County. Okay, so we have Warner and Swinging.
I'm sorry, Your Honor, may Officer Thomas be excused?
Yes.
Oh, he left. Thank you.
Yes. So we have Warner and then Swinging.
Okay, sir.
And Your Honor, just to confirm, did you receive an appointment order for Mr. Warner? From Ms. Gross? Excellent.
Yes. And I believe I returned it to Ms. Gross.
You did, Your Honor. I received this.
Okay.
Thank you, Your Honor.
Okay, so this is the position 24, State of Georgia versus Chad Warner. Mr. Warner is charged in warrant number 2021 CW 55161 with committing the offense of reckless conduct. Mr. Simeon, you may proceed.
Yes, Your Honor. The state would like to call Officer Das to the stand.
I'm here.
Good afternoon, Officer Das.
Good afternoon.
You mind raising your right hand for me? In the matter before you today, do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do, sir.
Thank you. Could you please state and spell your name for the court?
My first name is Sagar, S as in Sam, Agar. Last name is going to be Das, D as in Delta, A and S.
Thank you. 1 second. I apologize. I'm sorry, Your Honor. May I have 1 moment, please?
Yes, sir.
Thank you.
No problem.
There it is. Okay. All right. Ready, Your Honor.
Okay.
Oh, did I get you to raise your right hand already, Officer Das?
You already did.
Okay, thank you. Could you please, with whom are you employed, Officer Das?
I'm employed with the City of Forest Park Police Department.
And how long have you been employed with Forest Park Police Department?
A year and about a month. Almost
A year
coming
and
up
a
on
month.
2 months on the 16th.
Are you post-certified?
Yes, I am.
And have you investigated or responded to dispatches of this kind before?
I've been dispatched to calls referring to vandalism, but not with actually like fire involved. This is my first one, actually.
This is okay. Thank you.
No problem.
Now, I'll call your attention to the incident date of October 19th, 2021.
Yes, sir.
Sorry, 1 second. Just want to confirm. Okay, just confirm. October 19th, 2021. And now you responded to 4209 Jonesboro Road in Forest Park. Is that correct?
Correct.
And is that here in Clayton County?
Yes.
Now it appears that's a location of a mobile gas station. Is that correct?
Yes, sir. It's correct.
Now, upon arriving on scene, you made contact with the store manager, correct? Mr. Mapchan?
Mapchan, yes, sir.
And what did he communicate to you, officer?
He called in because he called our dispatch. He needed a report regarding the mail setting something on fire, and they just want to report for the insurance company. So when I got there, I spoke to him. He said a couple of his customers came inside and told him that, hey, is there a fire on the side of your building? And he ran outside to see what was going on. And he put the fire out himself. He took a mop bucket with some water or something, and he dumped it on there and put it out. Never contacted the fire department because he already put it out. He said a male came inside. The male, he does have camera footage of the male committing the act of a crime, and he left the scene before our arrival. The video described the male, and he said the male never came inside the store with a backpack, but when he was outside, he had a backpack on. Would appear that was set on fire. I sent the picture to a couple of my officers. They responded by saying they recognized the male from the picture because they dealt with him before, and he was issued a criminal trespass warning somewhere in that area, but not at that specific location. That's how they were able to determine and let me know that it was the male who actually set the stuff on fire. So I went to the back to see what was actually on fire, what was actually burned, It looked like it appeared to be a backpack with a candle attached to it. But there was no char marks on the building or any structural damage on the building. So at that point, he was gone. He was in there. I did not make an arrest on the scene, and I took out arrest warrants for the reckless conduct. I did submit a CSI request through my department to obtain a video footage. And to my knowledge, our CSI team, I believe they went out there and they did some other investigative work stuff.
Okay, Officer Das. Now you mentioned that the store manager stated that did he see or did he recognize the defendant as a person that came into the store without the backpack?
Right. He came into the store, but he never had a backpack on. It was after the fact when he went outside and they looked on the video, he had a backpack on.
Got you. And when he looked at the video from the outside and saw he had a backpack on, even though in store he didn't have one, outside he had one, was the store manager still able to identify and say, hey, this is the same person that was in the store earlier?
Yes.
Yes. Okay. And again, as you mentioned, when he went back outside, when he left out of the store and went outside, he had a backpack on then.
Right. He went to the back of the store and then did whatever he did, set it on fire.
Got you. And he set fire to his backpack near the building. Was it on the curb? Was it on the sidewalk attached to the building? Where was it, the backpack that was on fire?
It was like, how would I say, like it's like a walkway around the building, like you'll walk around the building.
Mm-hmm.
It was like on a walkway.
So it was on the sidewalk around the building?
Around the building, near the building, correct.
Got you. It wasn't on the ground next to the sidewalk. I mean, next to that walkway. It was on the walkway that's attached to the building.
Correct. That's correct.
Got you. And again, as you mentioned, that fire was set to the backpack that he had on his person that was noticed on video.
Right. And he just walked away from the scene. The video actually captured the scene when he was walking away from the scene. So by the time we got there, we weren't sure which way he went, but the video showed his clothing and how tall he was and all that type of stuff.
When you saw the video of him, did you see the video of him leaving the scene?
Yes.
Did he have a backpack on?
Nope.
He did not.
Not to my knowledge. Not to my knowledge. When he was walking away, no.
When he was walking away, he didn't. But when you saw the video prior to that, you saw him with a backpack on.
Yes.
And when he left, he had he didn't. To your recollection, he didn't have a backpack on.
Right.
Got you. Thank you, Officer Das. Your Honor, no further questions.
Mr. Suh.
Thank you, Your Honor. Hello, Officer Dawes.
Hello, sir.
All right, let's get into it. I want to talk about this video footage. Could you describe the quality of this video footage that you saw?
What do you mean by the quality of it?
Let me adjust my question. Were you present during this when the CSI was conducting their investigation?
No, the CSI, I submitted a request for the CSI to obtain the video footage, but the day of the call when I was out there, I actually reviewed the footage on scene. The store manager allowed me to see the footage.
Now, the footage, I'm assuming, did this include footage inside the gas station?
It showed the inside when somebody was walking in and when somebody was walking around the back.
Gotcha. Now, did the video show the somebody actually starting the fire?
Yes.
So there's a video on the side of the building as well? Is this a third video or is it just the right angle where?
I believe it's the right angle because there was only one video that I seen that was on the back.
Okay. Please describe, what was he wearing in the video when you saw the?
Go ahead. I'm sorry.
Oh, so let's be more specific. When you saw somebody on the side of the building on the video starting a fire, describe that person.
He was wearing a blue t-shirt with some blue pants and black and red shoes and a colorful type of garment on. with the backpack on, attempting to set the fire.
And I believe you said you sent a picture of the accused to other officers?
Correct.
And please describe specifically, how did you obtain that picture? Or what was the picture specifically and how did you obtain it? 2 questions.
The picture was obtained, actually I was on field training. I was on field training at that time. That picture was taken with my FTO phone, and we sent it to other officers that were probably familiar with the guy. And when we sent it to them, they was like, hey, they recognized the guy from the picture because they dealt with him before they issued him a criminal trespass warning in their surrounding area somewhere else.
Are those pictures with evidence right now?
I believe so. I believe the pictures of the items that were burned, I believe it. Yeah, I did attach them to the report.
Specifically, I'm wondering about the picture of the picture you sent to the other officers. That picture, is that picture in evidence?
I do not recall, but I think so. I do not recall.
And just to confirm, so you took a picture of the, I guess, the security screen? Is that
right? It's inside the store. Inside the store, yes.
Is there a zoom function on that security system?
Zoom function. You talking about like to go further into it, and yeah, it should. Yes.
So the security system had a zoom function.
Yes, it had some zoom function in there. It did have zoom function.
I'm just trying to better understand if the camera shows the front door as well as the side of the building enough where you can see somebody doing this. That sounds like a wide lens. So I'm just trying to better understand, how were you able to get an accurate picture of his face on that type of video?
Because the picture that I took was the one when he walked into the store, when he originally walked into the store.
Okay, so 2 videos. So the face picture was taken when he's walking in the store, and then there's. Go ahead.
They have multiple cameras around the store. So the camera that actually showed when they caught his face is the one when he was walking in, when he walked in the store.
And just to confirm, how were you able to compare the person walking in the store and the person that was on the side of the building? Just one more time, please.
Because it had the same type of same description that was on the camera.
Okay. All right. Thank you, Officer Dawes. No further questions, Your Honor.
You're welcome, sir.
Any redirect?
No, Your Honor.
May this officer be excused?
Your Honor, Officer Dawes may be excused. Thank you, sir.
Thank you. Have a good day.
You too. Have a good day, sir. Any argument?
Yes, Your Honor. Based upon the officer's testimony in the matter, the state requests that that the court finds that there is sufficient probable cause for the charge of reckless conduct against defendant Chad Oliver Warner, whereby Mr. Warner, after being identified on video on 2, even 3 separate occasions, entering the store, outside of the store with the backpack on, and then leaving the incident location, 4209 Jonesboro Road in Forest Park, Georgia, here in Clayton County, the location of a mobile gas station, without that backpack. And the officers, and the store manager, as well as the officer, finding that burnt backpack on the sidewalk attached to the building. The state requests that there be a charge of reckless conduct being found, because such burning of that backpack as close to a gas station, the building of a gas station, whereby there could have been any, I guess, remnants of gas particles, fumes, anything that could have ignited due to the fire set to that backpack, as close, not only as close to the building, but not that far from any gas tanks either. As we know, the gas tanks are fueled and filled at some extent away from the gas pumps themselves. There's different what's the word I'm looking for? Seals that are located adjacent to the gas station buildings. And we find that setting fire to that backpack as close to that building, as well as close to on the property of that gas station, endangers the bodily safety of not only the store manager, but also any patrons of that gas station. And it's a conscious disregard of substantial and justifiable risk of explosion or burning of the building at the very least, that'll endanger the safety of not only, again, the store manager, but could potentially harm any patrons that might frequent that gas station if, that fire were to, if any wind were to catch that fire and, that fire be attached to any fumes or any remnants of gas that would trace itself back to those fuel pumps. And for those reasons, Your Honor, the state requests that you find that there is testimony and evidence sufficient for a charge of reckless conduct against defendant Chad Warner.
Mr. Suh.
Your Honor, we will submit on the evidence and the testimony presented in this courtroom today.
Okay. So the evidence as presented is sufficient for me to bind this over to State Court of Clayton County. So that'll be my order as it relates to this. So the final matter we have, is Angela Swingett. So, Mr. Little, you've heard from the state. What is your response?
Your Honor, we'd like to have a hearing. I don't necessarily want to waive the hearing, so I would object to a continuance, Your Honor.
Okay, Mr. Simeon.
Yes, Your Honor.
What is your response as it relates to the officer not being present?
Your Honor, this is, to my understanding, the first time that this matter has been heard before, not only before you, but also before in a prelim hearing, Your Honor. We were notified yesterday, or at least I was notified yesterday, that there is a training conflict with respect to this officer. So the state is just requesting a one-time continuance of a week. He should be present on next, if the state consents. I mean, if the court consents, he should be available next Tuesday, the 15th. But it is a training conflict that that officer had no control over, and neither did the state.
I understand. She's charged with simple assault. And I'm trying to pull the records up to see how long she's been in custody. Let's see.
She's been in since December the 29th, Your Honor.
Okay, December 29th. Mr. Simeon, I'm inclined to dismiss this charge. Of course, the state can draw up an accusation 10 minutes after I dismiss the charge. So, yeah, I'm not unaware of what little power I have. But if this person has been in custody since December 29th, I believe we owe it to her as a society to not have her sitting in jail on a simple assault charge.
Understood, Your Honor.
I know you can't make the motion. So, Mr. Little, is there a motion?
Yes, Your Honor, we would ask the court to dismiss this warrant for lack of prosecution.
I will grant that motion. But I'm going to require you, Mr. Little, to send over an order for
No
me to
problem, Your
put my little signature on. So by my count, that concludes what we've had scheduled here today. Is that correct?
Yes, Your Honor.
That was what I was expecting. Yes.
I believe so, Your Honor.
Okay.
My apologies, Your Honor. Which was the last case that you discussed with the dismissal?
Angela Swangin.
Yes, yes, Your Honor.
SWANGIN.
Yes, Your Honor.
Mr. Warner was bound over.
Yes, sir. Thank you.
So, Mr. Little, you walked away with 2 victories today.
That's right, Your Honor.
I said you walked away with 2 victories today.
That's right. That's what happens.